You guys ready?
Yep.
Ready? All right, well, good morning. We will call this 1 more minute. We live? We are live. Good morning, Joint Judiciary Committee. It's great to see you on this Tuesday morning, June 15th. We have a full agenda ahead of us this morning, but our favorite morning is starting out with updates from the Wyoming Supreme Court and an update on electronic filing and electronic records. So we see the warm and welcoming judicial branch sitting in the very back of the room. Excited to join us this morning. So committee members, there's no need to do roll call on our second day. We did it yesterday, so we will go ahead and proceed with the agenda for the morning. If I see that Chief Justice Davis may not be here, or he is online. Wonderful. Justice Davis, welcome. It's great to see you.
Good morning. Shall I proceed, Madam Chairman?
Sure, please introduce yourself to the new members of the Joint Judiciary Committee, and we also have Ms. Butler joining us here live as well at the table. So I'm assuming you're both going to maybe tag team some of the information. So the floor is yours.
Thank you very much, Madam Chairman, Mr. Co-Chairman, members of the Joint Judiciary Committee. Thank you for the opportunity to speak with you about electronic filing and electronic records in Wyoming courts this morning. And thank you also for allowing me to appear remotely. By way of introduction, I'm Mike Davis, and I will be the Chief Justice of the Wyoming Supreme Court for another 2 weeks. Justice Kate Fox, who I believe is there or will be there, will take over as chief on July 1st. The chair's already noted Lisa Butler is there. I think we can anticipate seeing this morning Judge Catherine Wilking, District Judge from Casper, who is the chair of the District Judge Conference. I understand Judge Catherine Rogers from Cheyenne may be there. Judge Brian Christensen, who's the Circuit Judge from Natrona County and Casper, also the chair of the Circuit Judge Conference, is or will be there. Diane Sanchez is or will be joining us via Zoom. And I can see Diane is the District Court Clerk in Cheyenne for Laramie County. And Tina Wood, I can see on the video, who is the District Court Clerk in Crook County, Sundance. If it's all right with the chair, I plan to address electronic filing and leave the electronic court records portion to Elisa Butler and whoever she designates. And then Justice Fox was going to speak to the operational efficiencies topic at 9:30. Before I launch into a report on electronic filing at the, I guess now 4 levels of the Wyoming court system, a little background. This is a bit of oversimplification, but to have electronic filing, you need at least 2 things. Obviously, you need the software to allow attorneys and others to file electronically, but you also need a case management system. I'll offer an analogy that doesn't really hold up perfectly, but you could visualize the electronic filing system as the attorneys send to the clerk's office with a paper filing. This person, sometimes called a runner, hands the document over to the clerk and gets whatever receipt he or she needs and pays the fees. An actual electronic filing system does more because it makes service electronically on all the other parties for everything but the initial complaint, which has to be served personally. It may also distribute documents within the court itself, for example, to the judge or judicial assistant or law clerk. The case management system, on the other hand, is kind of like the court clerk and a filing cabinet. It accepts the filing, makes sure it's identifiable, and puts it in a location where it can be easily found later. It's the permanent storage place of electronic files. You can't have one without the other because whatever comes in needs to be retrieved and stored and retrieved. And in this day and age, what we've learned is that the 2 systems are often made and installed by different providers. There tends to be specialization, and that's the case of what we're dealing with today. So now on briefly to what we have. I'll start with the Supreme Court. As all of the attorneys know, we have had an electronic case management system and electronic filing system at the Supreme Court since 2008. It's called C-Track. It was developed right here in Wyoming before 2008, and it was the very first of its kind. It's now the most widely used case management system in the United States, in various states, and also the United States Court of Military Appeal. The system has worked well for us. However, it's very old, and it's been changed in other states in other ways. So in other words, as the Thomson Reuters brought that system into other states, they were constantly improving it, and we're still kind of stuck back with the original with some sort of ad hoc changes to it. We are so far behind that we would have to replace rather than upgrade that system. And we thought we were on track to get that done. The Joint Appropriations Committee recommended an appropriation of $1.7 million to replace the existing system with the most recent version of C-Track. But unfortunately, then the full impact of the coronavirus and the budget crisis hit. And this upgrade was one of the things we thought we could limp by without during these tough economic times. And so that appropriation was not approved for us. Anyway, so far we're getting by, and so far so good, but that system will fail eventually, leaving the Supreme Court without an electronic system if we don't replace it. So that is a priority. The next thing I'd like to talk about is the Chancery Court. I think everyone knows the legislature entrusted the Supreme Court with the responsibility of opening the Chancery Court, which is in essence to be a complex business litigation court with a very fast docket and no jury trials. Justice Fox spearheaded the effort on our end with a committee of lawyers and judges who are knowledgeable in this area. And we are pleased to announce that the Chancery Court will open as scheduled and as required by statute in December. This December, that's December 2021, with electronic case management and electronic filing from day one. And I'll tell you when I talk about the district courts, about the systems that we use in conjunction, I'll discuss that. It's the same system as the district courts, and I'll tell you about that when we get to the district courts. I'll just say this process has been easier for us to manage than district courts, electronic case management and electronic filing, because there's just one kind of case in the Chancery Court. It's going to be a civil action, whereas the district courts have juvenile cases, delinquency, abuse, neglect. They have criminal cases. They have various kinds of proceedings that require changes and complications to both case management and electronic filing. Another benefit to us to getting started is that the Chancery Court starts with 0 filings. It has no accumulated cases to be brought forward, as is the case with the district court. Everyone, including the Supreme Court, is very intent on getting electronic filing into the district courts as soon as possible. I won't go into a lot of history on this. I've spoken about it before. The Supreme Court had such a great experience with the Supreme Court C-Track program that it contracted with the company that built that system, which was a small outfit called the LT Court Tech. And they entered into contracts with that company around 2009, 2010, over a decade ago. Unfortunately, I think as it turned out, LT Court Tech sold out to Thomson Reuters, which the attorneys will know as the company that provides Westlaw, a research database. Thomson Reuters did roll out a case management system called Y-User that I think the attorneys know about beginning in 2014. That system is in use today. However, as everybody knows, and I've spoken about it a number of times, that did not turn out as we had hoped. And it was not a system we trusted to go to electronic filing with. But even so, Y-User brought some improvements, although without electronic filing, documents had to be scanned into it manually. And I realize that's ridiculous. The attorneys create a document electronically in their law office, print it off, have it carried over to the clerk of court, who then turns it back into an electronic document via scanner. But the good news is that once a document is scanned, the clerks don't have to handle the paper file to retrieve documents. Judges have been able to work electronically and remotely. A Laramie County District Judge can take a Park County conflict case and then just access the record online rather than having the paper file sent as in the old days. This eliminates a lot of handling of paper files. I know when I was a district judge here in Laramie County, I had 2 long shelves. They must have been 7 or 8 feet long. And there was a big ritual every week where the clerks of court and the judicial assistants would haul in files, and at least one of those shelves would be completely full. And sometimes the second one would be me. And then you had to dig through a paper file to try to find things. And that's certainly easier today. The Supreme Court uses that system because it's faster for us to tap into an electronic, say, Park County file than to walk downstairs to our clerk of court's office and dig through the paper file. We can also retrieve certain kinds of data that I think may interest the legislature electronically, although that will improve when we go to the new system. Anyway, we regrouped after the false start with Y-User, and we made progress. The case management system we chose to replace Y-User is Full Court Enterprise. Full Court, an older version, has been used in all circuit courts and in 15 of the district courts before Y-User came into being. Before certain legislation, the district courts actually bought their own case management system, and 15 of them chose Full Court. It's been a good product for us in the circuit courts. However, that system required a lot of configuration to make it fit the district courts, which included managing juvenile and abuse neglect cases with all their unusual procedures, as well as criminal cases. But the system is now ready and will begin to be rolled out in pilot courts next month. That is July of 2021. The case management system has to be rolled out and put in use before electronic filing for obvious reasons. There has to be something to e-file into. So we will start rolling Full Court Enterprise case management system out in Albany County next month and keep going until all the district courts are up on it. These rollouts are time consuming and they need to be done carefully so that data transfers. We have a tremendous amount of data from years of scanning in electronic documents, and they call it migrating. It has to be migrated from Y-User into Full Court, which is a very complex process. And test migrations have already been done, and that's going to work. Clerks also have to be trained to use the new system. This normally takes more than one set of trainings. It's just that they're trained before the system goes into place. But then after they use it a while, it's just, you can only absorb so much information. Then we have to have a retraining process, which is work for our staff, which does the training. But now at last, on to electronic filing for the district courts. Our court didn't trust ourselves to select an e-filing system, and so we set up an electronic filing committee composed mostly of lawyers from various practice areas with good experience with e-filing in the federal courts and other state courts. One of them was the current Wyoming State Bar President, Billy Adelman. We also had district judge, court reporter, and some clerks of district court. 3 well-established companies specializing in electronic filing programs demonstrated their wares to the committee, and they also set up what they called sandboxes or trial versions of the software that the attorneys and their secretaries or legal assistants could use to see how they would work. And I suspect it's fair to say that most of the electronic filing will not be done by attorneys, but rather by legal assistants, paralegals, or something like that. So their input was important. Anyway, an overwhelming majority of the committee selected File and Serve Express because of its many features and ease of use. We vetted the system with the states that already have it, and it got great reviews. The system will collect whatever fees are required and remit them to the clerks of district court at the close of business each day. It will electronically serve other parties when a filing is made. And so that's the system, and we think it's a good one. That's what will be in place in the Chancery Court in December. As for the district courts, we plan to roll the electronic filing out a year after each court's case management system comes up, unless we can figure out a way to do it faster. So I said that Albany County is the first to receive the case management system next month, and it would be July of 2022 that we would be planning to roll out full File and Serve Express to them, and then just keep going until it's in all the courts. But you may ask, how do you know this is going to work? Because we did have that false start with Y-User. President Drew Perkins, when he was president of the Senate, suggested that we get an independent study of our plan. And so we did that in 2019. We contacted the National Center for State Courts and ultimately wound up with the State Court Administrator for Delaware. Justice Management Institute, which has done this kind of study for various states and foreign nations, did ours. Their report is on our website with an executive summary so that you don't have to read the whole thing. Justice Management Institute concluded that in some ways we were ahead of other states, and I think we were primarily referring to our ability to conduct remote hearings using Microsoft Teams and Surface Hubs. And I think the attorneys will know they were proved right when we were able to keep our courts open during the pandemic, when our sister states often could not conduct as much business as we could. As to case management and electronic filing, JMI did conclude that we're on the right track with good software and a good plan to get to fully electronic courts. It did also conclude, however, that just to meet the timeline we set for ourselves, we are short 8 people based on what other states have needed. If we had another 8 people to work on this process, that would double those we have now. And unfortunately, I'm pretty sure we won't get those 8 additional people, no matter how persuasive any of us are. So even if you worked on your colleagues in the legislature, I think we're probably going to roll this out with the people we have. And I'm confident through hard and smart work, our small application staff is keeping up. That brings us down to the circuit courts, which are our courts of limited jurisdiction. Unfortunately for us, just coincidentally, about the time we decided we could not continue with Thomson Reuters and Y-User in the district courts, the full court system used in all the circuit courts reached what they call end of life in 2014, meaning that the company that built it would no longer maintain it. Well, the circuit courts handle about 125,000 cases a year, although many of them are traffic citations. But with that many cases, you really can't afford to have your system go down. So that meant we had to purchase and install the updated version of that program, which meant the same 6 or 8 people we need for e-filing in the district courts had to work on the circuit court upgrade. That began in 2018 and ended in November of 2020. I think our application staff, small though it is, did an excellent job. They compiled a 300-page how-to manual for use in bringing the new system online for use by the circuit court clerks and for their use. The manufacturer of Full Court Enterprise has recommended to other states going to their product. And in fact, we've been sharing it most recently that I know of with Montana. But now that this is finished, the small group of people we have can focus on district court case management and e-filing. I would be remiss if I didn't tell you that the circuit court judges really want us to get e-filing in place for them. And they argue, hey, we're ready since you have the case management system, let's do it. On the chance that maybe we could figure out a way to shift some work to File and Serve Express for not too much expense to get that system into the circuit courts. We have applied for ARPA funding for that system. Whether this is going to be determined to fit within ARPA or not, I don't know. That's a question that remains to be answered. Just as an aside, I would note we have a system in the circuit courts that allows remote payment of traffic citations. So if you're cited into circuit court, you can pay your ticket online. And we also have a sort of e-filing. The officers citing traffic violations can file the tickets electronically. In conclusion to this part, I would just add a couple of things. I learned of something called the Law School for Legislators that the Illinois Supreme Court puts on. I want to renew our offer to provide a 1-hour program that Justice Couts would put on for any legislator who's interested, in which we would record and put on our website. Justice Couts is ready whenever anybody wants to start that program. And we would also be glad to provide a more in-depth program for members of this committee if you have any interest. Finally, if you're interested in knowing what's going on with courts in your community, there is a district and circuit judge in every county, and they would be happy to visit with you about their operations. And of course, the Supreme Court's always happy to respond to any inquiries. And with that, Madam Chairman, I would be happy to answer any questions, but otherwise I would turn it over to Elisa Butler and whoever else is there to talk about the work of the Court Records Committee.
Questions for the Chief Justice? Representative Washut.
Thank you, Madam Chair. Mr. Chief Justice, thanks for being with us this morning. With regards to the ARPA funding, did your request go through the state or did it go to the federal government? Who's the decision maker on whether or not the ARPA funds will be flowing to the Supreme Court for the EMS program?
Chief Justice.
Madam Chairman, Representative Washut, Ms. Butler may need to jump in and correct me if I'm wrong, but we have submitted those requests to the state and they're being handled through the process that I think the governor and the legislature discussed within the last couple of weeks. And so I understand the approval will probably, I think the way the CARES Act funds were, the Attorney General reviewed these, the governor agreed to it, and then eventually we got the CARES Act funds. And I believe it's something similar for ARPA.
Ms. Butler, any follow-up?
Madam Chair, Representative Washut, that's correct. We submitted our request through the state. It's my understanding that this request will be heard by JAC as part of the budget process. I think that may be evolving a bit, but that's my current understanding.
Additional questions for the Chief Justice? Representative Yen.
Thank you, Madam Chairman. Chief Justice, appreciate you coming to talk about this. It currently looks like we're in the middle of the rollout. Is it possible for committee members to get maybe like a look at how the system looks, like a demo of some sort, just so we can see what the court is using? And start with that. We'll start with that. Thank you, Madam Chairman.
Chief Justice.
Madam Chairman, Representative Yan, yes, and I think particularly if you're talking about e-filing, File and Serve Express would love to do such a demonstration of that program, and we could definitely set something up for them to do that, they probably would be the best at it, although perhaps Ms. Butler can tell us if we can just sort of, if we can put on that kind of demonstration yet. I know we're still rolling it out.
Senator Cost.
Thank you, Madam Chair. Thank you for being here as well, Chief. My question is, we've struggled with the electronic filing and getting everybody on board with this. Are we going to make it past first base this year, or is this going to still be a struggle?
Chief Justice.
Madam Chairman, Senator Cost, well, we're obviously going to be to first base this year because we're going to have a fully functional Chancery Court, and it'll have electronic filing and full case management system. We have actually hired a combination law clerk, filing clerk, jack of all trades, who will begin that process. And the case management systems will be in place in the district court as we move along this year. And then by the summer of 2022, e-filing will be brought in online, court by court.
Any additional questions? Just a quick comment, Chief Justice. I know yesterday we spent most of the day discussing juvenile justice and the challenge the state has regarding data collection. It's unfortunate Representative Oakley's not here to hear that. You know, and it struck me that certainly if we had an electronic filing system, recognizing that juvenile court records are confidential, I certainly understand that, and so does everyone on the committee, but there is a way to still electronically file those and keep them confidential. that still would be a remarkable database for our state to use to make appropriate policy decisions regarding juvenile justice in this state, and where to allocate appropriate resources during a time of budget decline. So it's incredibly unfortunate that we're still here in 2021, approaching 2022, and no real ability to data collect. And so as we discussed, the Council of State Governments coming into our state and understanding that data and evaluating it, to realize, no doubt, that some of those costs require them to travel to every single district court in our state, and look at those court files manually.
Madam Chairman, I'm actually not sure that's true. If we gave them access through Y-User, they could access those files.
Did they do that for criminal justice reform? Do you know, Chief Justice?
I thought so, but maybe Ms. Butler knows for sure.
Ms. Butler?
Madam Chair, I don't know for sure because I don't believe I was part of those requests. What I can tell you is we do have a database of information that we gather from both the circuit and the district court that comes in through the case management system. And that comes in basically when the clerks enter data into those systems. One of the things that we have been working on over time is ensuring that data is accurate. I will tell you, I think you heard from Dr. Nunez yesterday, data entry and making sure it's consistent so that we can pull accurate data. That's a struggle, but it is something that we focused on recently. And we did that. We provided trainings throughout the rollout of the case management system in the circuit courts, and we'll be doing the same as we roll out in the district courts. As we do this case management system rollout in the district courts, there will be a shift in the way that we gather statistics and the way that we gather data. We are moving away from a Wyoming specific data gathering and more toward something that can be compared nationwide with other states. So there is a shift happening right now. You heard yesterday that it took the council, I believe, 24 years to get to where they are. I hope we will get there sooner, but it is a process. It does take time. And really a lot of that has to do with ensuring that the data is accurate and also that the data entry is consistent.
Ms. Butler, can you help the committee understand what information goes into Y-User and why there's a need for a clerk to input that data manually as opposed to the lawyer who's actually filing the documents with the court to identify what the case is actually about?
Madam Chair, absolutely. So part of that absolutely has to do with the fact that we don't have an e-filing system. The attorneys do not have access to the case management system. That is a system purely for the clerks. And so when the clerks receive filings, what they do is they will look at those filings and then they will enter them into the system. There are a few data fields that they enter in terms of litigants, the kinds of cases that they're looking at, the judge on the case, potentially dates, and then docket entries. So when they receive a filing, there's a docket entry or a register of action, what happened, what was filed, along with the scan of the actual document. So there are some data fields. The attorneys do not enter those data fields currently. When we do get to an e-filing system, there will be some data fields that attorneys will enter, and those will flow into the case management system.
Ms. Butler, in relationship to juvenile justice, would the Y-User system allow someone looking at it to identify the age of the juvenile, the date that the action took place, pending action for that juvenile's court case, and ultimate disposition?
Madam Chair, I believe it would, and I would have to go back and verify that with our database administrators, but I believe that information could be pulled. We would have to write specific reports for that. Again, the concern would be accuracy and ensuring that whatever data we provide is actually accurate. And that's, I think that's the real struggle and one of the things that we've had issues with in the past.
Can you explain that further? How do you know that the data is not accurate?
Madam Chair, it has to do, well, let me back up. I'll give you just an example. We have at the Wyoming Supreme Court, the Children's Justice Project. So that is, and we have a Children's Justice Project coordinator, Lisa Finke. She works every year on an audit that she does for the courts. It's the for abuse and neglect cases, juvenile cases. In comparing our data with other agencies, it doesn't always match up. And so that's one of the problems that we currently have. She spends an incredible amount of time reviewing that data, making sure it's accurate, and actually going through some of those filings, as you mentioned before. So the data exists. It's the accuracy that's the concern currently. And again, that's something that we're working toward to ensure that we provide training, and then to the clerks who have to enter that data to ensure that it's consistently entered and entered uniformly, so that data comes out accurately.
And is the need to provide that information for abuse and neglect cases a requirement to receive the federal funds that we do receive for that service?
Madam Chair, there are requirements through grant funding. I know that the Department of Family Services, as you heard yesterday, has their own system that they use to track that data. We do it, I believe it's part of the grant funding for the Children's Justice Project that they do that audit every year. So yes, it is part of those grant funding.
Additional questions? Representative Yen?
Thank you, Madam Chairman. So will the new e-filing system make it easier to make that information more accurate in the future for future cases?
Madam Chair, Representative Yin, I believe it will. I think it's really a twofold issue here, and we're working on both pieces. Attorneys will enter some of that data into the system, but also it's more about training, right? And making sure that data is accurate, and it is something that we're providing now. We have done limited training in the past, but it is more of a focus now moving forward as we move to this new case management system and a new statistical model.
All right. Anything further from the committee, from Ms. Butler or Chief Davis? All right, Clerk Wood, welcome to the committee. Do you have any comments you'd like to share?
I would just like to follow up that, well, good morning. I'm sorry, Madam Chairman.
And if you could introduce yourself to the committee.
Sure. Tina Wood, I'm the Clerk of District Court in Crook County. I am also a member of the Permanent Records Committee, along with several other members. I just wanted to add that, we do the best we can when we get the information and try to input the information into the system. I do know that we have a module in there that we also will input the dispositions, and when we do that, what the records are pulled from the Supreme Court, they get those requests. We do not. But I do know that the clerks of district court try to put in as much information as we get from the county attorneys when they give us the information as to the children, the parents, and make sure that that is in the system for those records. So I know that there is a total difference in the way we were trained initially in the YUSER program, and that is an issue. But I know that the Supreme Court is working towards getting us all trained the same with the full court enterprise rollout. And I just wanted to also let you know that, I've been on this work about since the beginning in 2008. I've seen the frustrations of the judiciary. I've seen the frustrations of the legislature, the attorneys, and I can also let you know that the clerks of district court have not been more frustrated, because we want to provide the best, because ultimately we are the boots on the ground that have to deal with these systems that are lacking. And so we're working very well with the clerks, with the Supreme Court, to make sure that we do have a system that's going to be workable. And so we're very proud of the relationship we have established with the Supreme Court. Yes, we've had frustrations, but we just need to make sure that we are moving forward. And that is our ultimate goal for the state of Wyoming.
Questions for Clerk Wood? Representative Provenza?
Thank you, Madam Chairwoman. And this question could be for really either of you or whoever could answer. Do you know if this electronic filing system would allow for more access to maybe digital dockets or like on the public end, not just on the filing system for the people involved in this, in the system, but the public? Would this be a little bit more accessible?
Ms. Butler?
Madam Chair, Representative Provenza, so what you're talking about is a public access system, a remote public access system. It's something that we have discussed for a number of years, and this is actually a great segue into the Court Records Division of the Permanent Rules Advisory Committee, which I'll talk about in just a minute. But it can be one and the same. It can be two separate systems. The e-filing system that we have could potentially work as a remote public access system. Currently, we are working to set it up or configure it for attorney use. So, that's something that we'll be looking at moving into the future is providing access outside of attorneys to provide, to have the information that they need.
Clerk Wood, just a quick question. In using Y-User in Crook County, could you be able to search that system and identify how many active CHINS cases are going in Crook County?
Madam Chair, yes, I would.
Okay.
We cannot do statewide because they are confidential, but anything in Crook County, yes, I can access, and also our judges could access as well.
And Clerk Wood, when do you expect to have e-filing up and operating in Crook County?
Madam Chair, I hope it's after 2022 when I am no longer in office. But if it's in between, but I have not got a rollout date for Crook County or the 6th Judicial District. I assume we would probably be all the same, but I have not gotten any notification as to when we would be in line.
Okay. Representative Zwanitzer?
Thanks. Thanks, Madam Chairman. And just because I'm somewhat not familiar with the background process, has it been a top-down approach from the Supreme Court, or has it been the district court clerks? You have an organization trying to get this coming to the Supreme Court. I'm not quite understanding the relationship on Supreme Court is making you do this. You really want to do this, and you're working as an association to all be on the same page and get there as quick as possible before 2022, hopefully.
Clerk Wood?
Madam Chair, Representative Sauer, I'm sorry, I just ruined your name, but we have in 2008, when this all began, because there were different systems within the state of Wyoming, the 23 clerks of district court agreed to work with the Supreme Court to have one case management system. And so with that, then the Supreme Court, basically the state of Wyoming, started funding our case management system. And so it's been a joint effort to make these programs work. Did I answer your question?
The ultimate answer, it's been a joint program, and you've all been working together for 12 years.
That is correct. Sorry.
As an elected official in Crook County, I'm sure you've heard last week, we had every other elected official had somewhat more passionate testimony. So thank you for being calm in front of us.
Thank you.
As those of us who are in corporations witnessed.
It was a good time. Additional questions from the committee? All right, Clerk Wood, thank you. Ms. Butler, just a couple of quick questions to maybe get the new committee oriented to the topic. I know I've been hearing this for a solid 5 years. So how is the electronic filing system funded, Ms. Butler? If you can just explain just quickly for the committee.
Madam Chair, I believe we received an appropriation last session, not 2021, maybe 2020. I'd have to go back and look to fund e-filing, the e-filing system in the district courts. And then we also received an appropriation to fund e-filing in the Chancery Court. So that is funded through the JAC, through the general fund. However, we also have what's called a Judicial Systems Automation account. That is a filing fee that is imposed on every filing in the courts. And that goes to an account that helps pay for various judicial systems, including things like the court or including court automation, including the case management system, potentially e-filing if more is needed, and then also some of the courtroom technology that the Chief Justice mentioned earlier.
Co-Chairman Olson.
Ms. Butler, refresh my memory on that automation fee. How much is it currently? And I think I feel like in my 5 years, we raised that automation fee twice. Is that accurate?
Ms. Butler.
Madam Chair, Mr. Co-Chair, that is accurate. We have raised the fee twice in the recent years. I think it was raised from $10 to $25, and I cannot tell you the year that happened. And then most recently, it was increased to $40 on case filings.
I think it was 2017. And what is that pool created in terms of funds?
Ms.
Sorry.
Butler.
Madam Chair, Mr. Co-Chair, it is used for various purposes, including, as I said, court automation, courtroom technology. It also pays for the salaries of some of our staff. So I guess most of the application staff, so that is the staff that works on the case management system and the e-filing system, they are paid out of that judicial systems automation account. They are not generally funded positions.
Madam Chairman.
Co-Chairman.
Sorry, that was helpful. But my question is, what is the total amount of dollars in that pool? And that's, sorry to put you on the spot.
Madam Chair, Mr. Co-Chair, I don't know that number off the top of my head, but I can get it for you.
Okay. Yeah, just interested in maybe to make it easier, one simple number actually, since we're talking about that we've been working on this for 12 years. Maybe you could send around to the committee, even just a follow-up email, just what is that total dollar amount that we've appropriated in grand total? You don't have to break it down to by session or from the automation fee. Just curious on what that total appropriation would be, direct from the general fund and from the fee, if that's possible.
Ms. Butler.
Madam Chair, Mr. Co-Chair, just one clarifying question. You are looking for a number on what we have spent on e-filing in the case management system. Is that correct?
No,
A total number, or just a total number in the judicial systems automation account?
Madam Chairman, Ms. Butler, I guess we could have two numbers. One, the total amount appropriated, which I suppose I could get that from our staff, but I suppose you would have the total amount that goes in over the 12 years. And then, yeah, what you just said would be helpful too, the total amount spent.
Further questions, Senator Cole?
Thank you, Co-Chairman Nethercott. Well, I'm new to this, so I'll just start off by saying that and I'm not the government, but into this question. Listening to all this as a person for the first time, I come up with a question, and it's this, and I don't know who the right person is to answer this, but where might be the most accurate data source? Is it from the courts, which I kind of assume, and the clerks are in the recording business, which I'm kind of familiar with? But I wonder, because I hear the talk, and the question is what are we doing? Obviously, it's not going very quickly, and we're still kind of moving forward, but with the direction of an outcome that we're still kind of uncertain. I look at this and I think we've got an issue with multiple people inputting data in multiple stages potentially, which leads into multiple misinformation potential, right? It's in industry, we try to get it at the source and then disseminate electronically. So we don't have clerical mistakes, which are inevitable with handling data. And accuracy is, I think, what we're all after here. So listening to this, where might you think if we were going to go to electronic system and then pull the electronic data like a form, where might that be? And then would that be something that would be advantageous, or maybe we're already doing that? And I'm sorry if I ask a redundant question that you've talked about 10 years ago. Thank you.
Ms. Butler.
Madam Chair, Senator Cole, but I guess the most accurate data that I know of that we have, I don't know that I can answer your question directly. And the reason for that is exactly what you've said, is the different agencies and the judicial branch collect that data in different ways. And there are different data sets or data fields that are entered. And so if we're talking like criminal cases, I'll give you an example. We have the Criminal Justice Information System. So that is through DCI. We feed them information, but they also get information from county attorneys' offices and other agencies. And so they have a fuller picture of that criminal history information than we would have at the court, because there are some cases, for instance, that are charged, or that somebody is arrested, but then the county attorney doesn't charge. And so I would say it depends on what kind of data you're looking for, on who would have the most accurate data.
Specifically, so all these cases though are decided by a judge. Am I right on this? Right? Not by clerks or anyone else. So the judges ultimately make a decision of some sorts. Well, my thought would be is, why wouldn't the judges then be the ones, that group, that body, the judicial branch, be the ones inputting data on an outcome of a case? And that would be our pure source of data. Then we would take that information and then pull it in a way that other folks could use, that are appropriate, right? Because this is highly secured material in certain cases, of juveniles or whatever it may be. But going to that source and then using that as our database, and then taking that information and disseminating that information. I'm asking an open-ended question. I just don't know where we're going. It seems like the bureaucracies I've been involved with in the county level end up just like what we're hearing, because of the conflicts between elected offices and the branches of government. So I'm wondering, would that be something that would be talked about, or what would you think about that? It just as a question. Thank you.
Ms. Butler?
Madam Chair, Senator Kolb, absolutely. We do enter that data currently, and we can pull that data currently. It's just, again, making sure that it's consistent and accurate is the big piece, and something we're working on. And I know Ms. Wood has something she would like to add. So I'm gonna.
Clerk Wood?
Madam Chair and Senator Kolb, if I can just explain our process, because ultimately it's our office that enters that information into the system. When we get a criminal bind over from the circuit court, we put all the information we have that is attached and comes over from the circuit court regarding that defendant, the charges that she is charged with. All of that information is put into the system. Then we put all the documents in. Putting the document in means we are just recording that document. Ultimately, when that defendant is found guilty, we put in, there is a module that is the disposition, and we are supposed to be putting in how that defendant was sentenced, whether he was incarcerated to the Wyoming State Pen, the local jail, whether he was probation, all his fines and fees. Then in my county, I put on any probation revocations. Now, whether that is happening across the state, I don't know. Again, that's a training issue, but that is a part of the system that we have. And I believe that it's in full court enterprise as well, that all of that information will be recorded in the system. Juveniles, the same thing. We put in all the information we have. Most of my juvenile petitions come over with date of births, social security numbers, any kind of identifiers. We are putting those into the system, addresses. Again, when we get a disposition on a child, whether it's a chins, a neglect, abuse, or a delinquent, there is a disposition field module that we enter what happened to that child. If they were out of home placement, whether they're at home, in juveniles, there's not a lot that you can put in there, but we do put in, at least I do, I put that information into the system. Any probation revocation on a delinquent, any review hearings, because I know that the statutes say that they have to have review hearings. And so I record the review hearings. And if there was any change in dispositions, I put that on. Again, I can't say that's done across the state. Again, a training issue, but that information ultimately relies on the clerks of district court. So, we are trying to do the best we can to enter the correct information into our system.
Follow up.
Thank you. I understand. I was really pointing out this conflict,
Mhm.
a conflict which I know exists because I've heard it before. But I guess my goal is trying to, be part of a solution.
Mhm.
And but the conflict we always run into is elected officials are just that. They're individual elected officials and they do what they do. And you're right. You do what you do and they do what they do. And the issue is consistency. So I'm kind of thinking about other ways of maybe skinning the cat, and it may be another solution. But I think inherently that's why it's taken all these years. I mean, you elected officials are elected officials. They don't like being told what to do. I get it. I was one of them. I am one. But that's why I was asked. You said it. I appreciate your candid comments and your honesty about what's going on. But we need to get a solution. That's all. And I want a good, accurate one, and everybody does. But the goal is how can we work? Who? I understand it's your elected position to do this, the record keeping. But how are we going to get conformity? When the judges are the ones that come up with an answer, they can make a judgment, a disposition, and then you record it. So we've got an extra step involved into the decision that was made. So I just wondered if there's some other way of doing this that will get us to our goal. I mean, listen, I hear the conflict. It's not going to be solved by someone saying you work with someone else. It's going to be solved by someone making a decision, a tough one, about what the future of the records are, how they're handled, and we need consistency. I agree, no matter where it's consistency. But if we can do that, I don't know I don't know. I'm probably just being rhetorical. What can we do to get there? I mean, I think frustration. What are we doing? I've never heard this happening in industry, but I know it happens in politics. And like you say, you're going to retire, and you're probably a very knowledgeable person on the subject. And where do we go? Start again? So I hope we can come up with good solutions that we can all agree are good and not have infighting. I think that's the way forward. Thank you, Madam Chair.
Representative Washit.
Oh, wouldn't you agree?
Thank you, Madam Chairman. Ms. Butler, the Chief Justice mentioned that one of the reasons we're able to get the Chancery Court up and running by the end of this year is that we don't have historical data to migrate into the system. And I guess in one of my previous roles, we dealt with a lot of historical data, and we simply took a date certain and said everything from this date forward will be in the electronic system, and the other stuff will be in a separate system. And we'll just have to operate with two systems, knowing that if the date on the document is before this date, it's going to be in hard copy version in somebody's file cabinet. And if it's after that date, then it's going to be in the electronic format. So my question is, I'm sure you've considered the possibility of simply saying, September 1, 2021, everything that date forward is going to be in the electronic file, just like we're doing with the Chancery Court. So what I want to understand is how much of a bottleneck this migration issue is, and whether or not it's a viable alternative to simply take a date certain and have two systems for a while.
Ms. Butler.
Madam Chair, Representative Washit, it's a good question. I think the bottleneck that we've experienced, I would say more with the district courts rather than the migration, although the migration is a piece of it, is the complexity of the district court itself. So in the case management system, there are a number of different pieces that we have to develop, and one of them to be completely honest, is a juvenile module to accommodate juvenile cases in Wyoming, and that has taken some time. In the distinction in Chancery Court is there is one type of case. It is a civil case. It's pretty darn straightforward, and it's not that hard to configure. The district courts are more complex. The migration issue, I hear, we actually did do that, I believe, and Tina knows more than I do because she worked on the project when we moved to Y-User, but we didn't migrate data into Y-User when all of the district courts, or we didn't migrate all of the district court data onto Y-User when they all came onto one case management system. It creates a few different problems now. One would be that public access would be limited to that date forward. So we're moving to a new case management system, and essentially we would have to build, as we get to the e-filing system, if you have an ongoing case, so a case from Y-User that goes to FCE, we would have to build an integration with the e-filing system to integrate with both of those systems for cases that have carried over between those two, if that makes sense. I hope I'm making sense to you, but what would need to happen, so they're two, e-filing and the case management system are two different systems. They have to talk to each other. And so if we said, okay, from this date, 2021 forward, we're not going to migrate any data into the case, the future case management system from the old case management system, the e-filing system would then have to talk to both of those. That would be incredibly complicated to do. So it really does make more sense to kind of bite the bullet, get the migration done, get all of the information we need into the new case management system so the e-filing system will work the way that attorneys and the public expect.
Representative Zwanitzer.
Thanks, Madam Chairman. I'm questioning how is information removed from the system? My primary question is you have a juvenile case, it gets expunged when they reach age of majority. Who ultimately deletes that case, or does it ever truly get deleted? And just the process of how that works to ensure that an expungement or someone comes 20 years later to get their record expunged, does it truly go out of the system? Or is it actually stay there forever and we just don't talk about it?
Ms. Butler.
Madam Chair, Representative Zwanitzer, so there are two different kinds of expungements in Wyoming, juvenile and adult expungements. The adult expungements, what happens in the case management system is the clerk does this process. If an expungement is granted, they will go into the case management system and there's a way to expunge that case. It essentially takes the name of the person off the case, so that if there's a public record search, that person's name will not come up on a case that there's been a charge on. They still have the paper file. It gets sealed and taped up and on a shelf somewhere. So because there is the possibility for an adult expungement to reopen that case, somebody can move to reopen that case. For juveniles, it's a little bit different. If they request an expungement based on, there was an amendment to the statute a few years back, and those are now destroyed. And so there is a process that the clerks have to go through. And I will tell you, it's pretty tedious on the juvenile ones, but they literally go through the entire system and delete every reference to that juvenile anywhere in that system. And then they will get rid of the paper file. So that file no longer exists. Now, I will tell you, we do have backups of the system. Those go into cold storage, whatever. We don't open them. And it's part of the statute. It was part of the conversation when that juvenile statute was passed, and DFS has the same. Those sit in the backups until they go away. So we take backups every day. At some point, when a backup gets old enough, it gets deleted. So there will come a time when that expungement or that juvenile case will be entirely deleted from the system. It just takes a little bit of time to get it out of the backups, at least on the judicial branch system. I can't speak to the DFS system.
Further questions? Co-Chairman Olson.
Thank you, Madam Co-Chairman. Okay, so I think I've got some budget numbers. So maybe I'll modify my question to you a little bit, but you can confirm, after you are able to look these up, that they were accurate for the record. But it looks like the appropriation in 2020, and I believe that was just for the district court automation, I'm showing 2.127 million in general funds. That sounds about right. And then $17 million in special revenues. So the special revenue would be the court automation fee. And I'm showing as of today, a balance of 8.142 million remaining in the account. So it looks like my math tells me half of that 17 is spent. So my question, I want to, please verify that all of that's accurate when you report back to us. But of the remaining 8.1 million, I'm curious where that's at in the process. If it's obligated under contracts, and we're rolling those out now and we're expending that money, or if we've spent up to date what we've spent and we don't have that obligated, and then what the plan is.
Ms. Butler.
Madam Chair, Mr. Co-Chair, so the amount out of the JSA is appropriated, and I will tell you, we don't always use it. So we ask for permission to use that funding out of the JSA account, but we don't always use it all within that biennium. So I would imagine it's both. I would venture to guess, and I would have to verify this, that some of it is obligated and will be spent this biennium, and some of it is not obligated and will remain in that JSA fund.
Madam Chairman, so that makes sense then, because the general fund appropriation was reduced in 2021 to 7.6 million. But that's probably because you didn't request to use all of it.
Madam Chair, Mr. Co-Chair, again, it's a guess, but I would venture to guess that's correct. We don't always use that entire appropriation.
Okay. All right. So, yeah, we'll circle back to it, but just want to make sure we're understanding over the 12-year period exactly what we have spent. I think that's accurate, which would be 8.1 million. But you'll be able to confirm that. Thank you, Madam Chairman.
All right, committee, any final questions on this topic? All right, with that, everyone can, I think, stay in their hot seats or flip a few out. We will move to our next topic of the morning, operational efficiencies in Wyoming courts. Mr. Fuller, did you have a presentation you'd want to walk us through?
Madam Chairman, I can highlight the topic overview that is in your materials. It's 7-01. I would defer to you how you would like me to proceed.
Yeah, Mr. Fuller, why don't you? We're comfortable with that process. So please start us out on the topic.
Yep. Very good. Members of the committee, this the topic summary really covers just a broad and basic overview of the court structure in Wyoming. It also, at the direction of the chairman, includes a couple of state structures that are similar in size, South Dakota and Alaska. And then I'll highlight a couple of bills that the committee considered last year as part of this topic. The committee mostly reviewed the constitutional provisions and statutes that concern the governance of the Supreme Court, and particularly in relation to the district courts. And there was also a bill draft regarding judicial workload studies and a requirement to complete those on an annual basis. So the judicial power, Article 5, Section 1 of the Constitution is vested in a Supreme Court, district courts, and such subordinate courts as the legislature may, by general law, establish and ordain from time to time. The Supreme Court has noted that the term district court is used in a broad or inclusive sense, as if there were one district court in a given judicial district. Article 5, Section 2 provides that the Supreme Court, quote, shall have a general superintending control over all inferior courts under such rules and regulations as may be prescribed by law. And the court has described this as a general superintending control over all the courts of the state and the Wyoming judicial system in general. And this section, the court has noted, supports the inherent right of courts to prescribe rules. Article 5, Section 13 provides for the clerks of district court and makes those an elected position. And then there are two statutes that may be relevant to this relationship. 53102B provides that district courts shall be free of administrative and fiscal control by the Supreme Court. This section also establishes the district court's judicial conference, The conference, among other things, is required to adopt suitable rules to provide for the division of work between the judges in multi-judge districts. 53113 notes that districts are required to submit standard and supplemental budget requests to the legislature. The practice in terms of the budget has been to treat each district court as a separate entity, and it's treated as its own agency, and it has a separate agency number in the budget. There's no, I found no case law or provision about the nature of the district courts or how the Constitution's general superintendent control applies to the district courts, particularly given the statutory enactments regarding those courts. The topic summary also covers, I'll just briefly note this, the nomination and terms of justices and judges in the state. Statute provides for the breakdown of judges by district, as well as where in districts with multiple judges, where those districts or where those judges must be based within the district. Before I move on, I'm happy to answer any questions about Wyoming courts.
Committee questions of Mr. Fuller? Does everyone understand where we're going? Does anyone need a break right now? Just want to make sure we're focused. Thank you, Mr. Fuller.
Okay. Thank you, Madam Chairman. Moving on to unified courts, and I'll let Ms. Creech highlight that there was there are two materials that were provided to the committee last year and were also provided again this year. But before I do that, I just want to highlight the two states that are included in the topic summary for consideration. Just broadly speaking, a unified court system is one with a single structured court that is divided into multiple levels, generally a trial level and an appellate level. These courts are generally consolidated. They have centralized management, centralized rulemaking, budgeting, and state financing. As part of this summary, I looked at Alaska and South Dakota. Alaska's constitution creates a unified judicial system and requires the Supreme Court to make and promulgate rules governing the administration of all courts within the state. Their structure is slightly different in that they have an intermediate appellate court. So they have a Supreme Court, an intermediate appellate court, and then two trial courts, one of general jurisdiction, one of limited jurisdiction. The Alaska Supreme Court has noted that its rulemaking power is explicitly broad and very nearly complete. And the Constitution provides that the Chief Justice is the administrative head of all courts, and there's a single budget for the entire judicial branch in the state. South Dakota's Constitution is similar in that judicial power is vested in a unified judicial system. The Chief Justice, again, is the head of that system. And the Supreme Court, under their constitution, is granted general superintending powers over all courts and may make rules of practice and procedure and rules governing the administration of all courts. Their structure is identical to Wyoming's. They have an appellate court and two trial courts, one of general and limited jurisdiction. The Chief Justice has and exercises general direction and supervision of the work of the circuit courts, which are their courts of general jurisdiction. And circuit judges are required to report on undecided cases after 90 days to the Chief Justice. With that, Madam Chairman, unless there are questions, I'll turn it over to Ms. Creech for a brief update on the unified courts.
Wonderful. Ms. Creech, the floor is yours.
Madam Chairman, Committee, Danielle Creech, LSO. For those of you who were here last year, you'll recall that I presented a report on state court structures and judge selection. In your materials, this was updated by a colleague. It's material number 7-02. This report was updated this year, so in the interest of time, I'll just focus on the updates and the court unification section. Recently, many states have moved toward unifying their courts to centralized court administrative authority, as Mr. Fuller said, as well as rulemaking powers and consolidate state and local trial court funding. 26 states currently define or describe their courts as unified or as one court of justice, either in their state constitution, state statute, or by court opinion. It's important to note that many states define unified courts differently. Appendix B will give you a table of those states which do define their courts as unified. Some that I will note that are near us, western states, are Idaho, Kansas, North Dakota, and South Dakota. As a brief history of the unification of courts, in 1917, the American Judiciary Society issued a model act that defined a unified court system as kind of having three key elements. First, a two-tier trial court system, as Mr. Fuller said, one for lesser matters and one for greater matters. Exclusive authority for writing rules residing with a state judicial council comprised of the state's top judges, and administrative authority over the courts residing with the Chief Justice and Judicial Council. After the 1917 Model Act, the Judiciary Society issued additional and sometimes opposing ideas regarding unified courts. And those include a one-tier trial court system, the state Supreme Court rather than the Judicial Council having the rulemaking authority and administrative authority over all the courts in the state. The state's courts administrative authority having budgetary authority over all the state courts. And all courts 100% state funded. So with that, I would stand for any questions the committee might have.
Questions from the committee? Briefly, Ms. Creature, Mr. Fuller, if it's in here, I apologize. And if you don't recall either, that's fine. Do you know when Alaska became unified? And South Dakota?
Madam Chairman, unfortunately, I do not have that information, but I'd be happy to look it up and get it back to you.
That'd be great. Thanks. Any questions of Ms. Creech? All right, thank you both. With that, we will turn to Justice Kate Fox. Welcome, Justice Fox. Good to see you here this morning at the Joint Judiciary Committee.
Thank you, Madam Chair. I am Kate Fox, Justice of the Wyoming Supreme Court. I will be taking over as Chief Justice in a couple of weeks from Chief Justice Davis. I think your staff has done an excellent job of summarizing the court structures nationally and somewhat in the state of Wyoming, but I thought it would be helpful to give you a quick review of how it works here. And can I put that report up on the screen? You have this diagram in your materials of the Wyoming Judiciary. It's okay. There you go. So there's this Supreme Court. There are 5 justices. This is a constitutional body. Then district courts, there are 24 judges, also constitutionally established. And they are spread throughout the state in the 9 judicial districts. Circuit Court, also 24 judges. That is a court of special jurisdiction that's created by statute. And you'll see off to the side is the Chancery Court, which the legislature has established in some 2019 legislation. As the chief told you, that will be up and running on December 1st of this year. And then I have municipal courts there outside of the box, and that is to explain to you that they're not a formal part of our judicial system. We don't employ them. They're not selected by merit selection. They're hired by their mayors. Some of them aren't even lawyers. We do try to provide training, but other than that, they're kind of on their own. So next page, I mentioned judicial selection.
Can we stop there for just a minute?
Certainly.
Justice Fox, thank you. Committee members, do you have questions about that right now? I have a couple of questions, and this is for Mr. Fuller or Ms. Creech or Justice Fox, if you know. In the unified court systems, are the municipal courts subsumed into that unified system, or do they remain kind of that separate thing? Mr. Fuller?
Yep, Madam Chairman, I don't recall either of those two states. Those are the two that I focus primarily on, referencing municipal courts within that at least the constitutional structure.
Madam Chair, it's my understanding that the municipal court structure that we have in Wyoming is typical. I know in Colorado, for example, the municipal courts are run by their municipalities. The judges are hired by whatever the governing body is there. And in some cases, they are viewed by the governmental entity as fee generating, which is not at all how we view the judiciary.
Thank you, Justice Fox. Can you briefly tell the committee the types of cases that a municipal court has jurisdiction over?
I can tell you what I know, which isn't a whole lot. So, there's a municipal code. So if there's a code violation, it may go to municipal court. I don't actually know if there's a distinction, if there's say a charge under a Wyoming statute that could go to circuit court or could go to municipal court, how that decision is made.
I think it's made by the officer. No, yeah, DUIs, and at least in Laramie County, are made by the discretion of the officer for which court to go into. Just Judge Christensen, come on up. I think this is actually a very interesting topic and helpful right now. And just also to help segue for juvenile justice on that topic as well, we heard information yesterday, testimony yesterday, that part of that data gap also comes from kind of the disconnect with our municipal courts as well, many of whom also have juvenile diversion programs, and they also can receive juveniles for ordinance or statute violations that would be appropriate in that municipal court. So for juvenile justice concerns, the municipal courts also present a unique data gap as well. Judge Christensen, welcome. If you'd introduce yourself to the committee and help us understand.
Thank you, Chairman Nethercott. Brian Christensen, Circuit Court Judge in Natrona County, President of the Circuit Court Conference. It could happen that a law enforcement officer can select which court to write his tickets in, but that's controlled by policy, usually by an agreement between the county or district attorney's office and the chief of the municipality or the head of that law enforcement agency. Some communities, such as Sheridan right now, are writing all their DUIs. Sheridan police departments are writing all their DUIs into circuit court. In Casper, law enforcement's CPD is writing their DUIs into municipal court. However, if they are drug-related DUIs or if they are enhanced DUIs, they would be processed through the circuit court. That is fluid based on budgets as to number of prosecutors, that there was a limit, and I'm sure the Laramie County people are familiar with the cut of the budgets for the district attorneys, and that had some bearing on what charges are being filed in what court at the present time as well.
Yeah, thank you, Madam Chairman. Judge Christensen, so to break down the types of cases, particularly because as you heard yesterday, our topic on juvenile justice, and I mean, trying to make sure that whether it's an adult or a juvenile, we get them into the right program, period. I actually didn't know until Justice Fox said that some municipal courts there's no requirement for that they be a lawyer, for example, or be bar certified. And I find that very interesting. A municipal violation obviously could be spitting on the sidewalk. It could be caroling. when it's prohibited in Cheyenne in our statute. Bizarre. But so those we probably, I don't think most people are concerned with who sits at the bench to deal with those types of infractions. But a DUI, much different. You know, we're blessed in Cheyenne that our municipal judge is certainly learned in the law. So I think and spent a lot of time dealing with criminal justice matters in the legislature as well, and can probably guide good policy decisions. So I'm curious what we know more about those municipal judges. I imagine that where they're not a lawyer, I imagine those are very rural communities, and there isn't anyone.
Justice Fox.
Madam Chair, Representative Olson, I shouldn't overstate this. I think it's pretty rare. I don't know how many non-lawyer municipal court judges are left in the state. I know it has occurred.
Madam Chair, Chairman Olson, also just a couple points on that. I think in Sublette County, a few years, a magistrate you saw even in the circuit court system was not an attorney, which came up on an ethics issue. Also, as to charges, the big misdemeanors are DUIs, possessions, and family violence. All of those can have concurrent jurisdiction. Those are by agreement, and because there's such a focus on domestic violence, almost all municipalities will present their charges for domestic violence into the county or district attorney for filing in circuit court. For possessions, there's been a recent trend as well that possession of marijuanas are being referred back to municipality courts. You're not seeing those in circuit court as much. And so it just depends on agreements, workforce, resources, all those things come into play on those matters.
Madam Chairman, excuse my ignorance, but do you have to be a licensed attorney to practice in municipal court? Is it just a small claims court where you don't have to be a licensed attorney, or?
Madam Chair and Chairman Olson, I have not studied that, so I could not tell you. I just know they exist. And there was a time frame that some of those positions were grandfathered in the change of the system, how it was set up in the 90s.
Oh, no, sorry, Judge, I'm talking about practicing in the court.
Oh,
representing somebody.
Oh, representing. Oh, yes, I'm sorry. Yes, and now in FEDs as well. FEDs, you do not need an attorney to, if you're an LLC, you don't need to have an attorney to, if you're a business, come in to represent that LLC.
I do remember that unfortunate bill.
Yeah, it starts July 1st, Mr. Chairman.
Okay, thank you.
Representative Washit.
Thank you, Madam Chair. I think I'm accurate in this, so I want to make sure we're clear that municipal court fines return to the general fund of the municipality, and in circuit court, district court fines go to the school fund. Is that correct?
Judge Christensen.
Madam Chair, Representative Washit, that's correct. And that single point of entry that was talked about yesterday became one of the reasons that became codified, was because some law enforcement agencies did not want to share their citations with district and circuit court because they thought they were losing their funding. And most of them found out it was costing them more to prosecute juveniles than to give them to the single point of entry program.
Thank you, Madam Chair. Do all of the status offenses have concurrent jurisdiction between municipal courts and circuit courts?
Judge Christensen.
Topic near and dear to my heart. Chairman Nethercott, Representative Washit, several years ago, I tried to get a bill when I was with the district attorney's office that We would have concurrent jurisdiction for status offenses like curfew violations or those sort of things, so that single point of entry could control all the children that came in before them, have them in one court, one probation officer, all the reasons that you heard yesterday, why we have single point of entry. That didn't succeed. There was a belief that it would significantly impact the judiciary's caseload system, which I won't comment. This was before I was in the judiciary. That was many years ago, but those cases are still going referred by single point of entry and usually just pocketed because there are delinquent charges that can be brought either in diversionary programs, and they can also be referred for, say, if there's a vaping ordinance that's not referred in state statute, they can go to their tobacco education and vaping education program without going to any court. So it's still reviewed by single point of entry, and there's still an effort to keep all those citations by juveniles out of municipal court.
Representative Provenza.
Thank you, Madam Co-Chair. So do the municipal courts have the same kind of toolbox of what programs they can use, or going back to the diversion, that the district or circuit courts would have available?
Madam Chairman, Representative Provenza, unlikely. The system is set up for circuit court probation as Department of Corrections is their probation arm. It just depends on the municipality if they have a probation arm or what that would look like. They may have fines only versus maybe some jail time, but probation would probably be unsupervised. Some municipalities do have some system of probation, but it's rare.
Wonderful job on providing a little primer on the municipal courts, what you were not intending to do nor have experience in. Appreciate stepping up to the plate there. Justice Fox, please continue with the presentation. Judge Christensen, you may as well just stay close. We might have more questions.
That's what I think. Madam Chair, thank you. One last thing on this page, Mr. Fuller mentioned this. Unlike most states, we do not have an intermediate appellate court. So cases can be appealed from the circuit court to the district court, or cases can be appealed from the district court to the Supreme Court. In most states, you would appeal from the district court to an intermediate appellate court, and then the Supreme Court would only take certain cases which they accepted cert on the same way as the United States Supreme Court does. We don't have one in Wyoming, and we don't need one. I think our volume is quite well handled by the structure we have now. Okay, so aside from municipal court judges, all 53 of our Wyoming state judges are selected by what we call the merit selection system. And what that means is there's a commission of 3 attorneys elected by the state bar, 3 lay people selected by the governor. The chief justice is a non-voting chair of that commission. And the commission accepts applications when there's an opening, interviews the most qualified candidates, and then sends 3 names to the governor. The governor has 30 days to choose from those 3 names. We think it's a pretty great system, much better than an elected judiciary, because in the states where judges are elected, they have to raise a lot of money. And who gives them money? People likely to appear in front of them. There's an inherent conflict with that system. Our allegiance, unlike you elected officials do owe your allegiance to your constituents. Ours is to the rule of law. And I think that this kind of selection system helps to ensure that. Yeah, also I should mention part of the merit selection system does give the people a voice, and that's in the retention elections. So you'll see our names on the ballot occasionally. It's not a contested election, so when my name's up, nobody runs against me. But if enough people want me to be gone, then they can vote, don't keep her. And then the selection system will begin in the same way. So there is a mechanism for the people to have a voice if they feel strongly about a particular judge. Also, another mechanism that's going to be very effective on Chief Justice Davis soon is we have mandatory retirement at 70. The circuit court judges don't. That's not, for some reason, a provision in their statute, but district court judges and Supreme Court justices must retire at age 70.
Justice Fox, we have a question from Representative Yen.
Madam Chairman, thank you. Justice Fox, do you know how often generally judges lose their retainment elections?
Yes, Madam Chair, Representative Yin, it's very rare. I think I would guess maybe 5 judges in the last 20 years that I'm aware of have been non-retained. 1 justice and roughly 5 judges. I think a problem is that I don't know how many times people ask me, hey, I saw a judge's name on the ballot. What's that about? So it would be better if we had a more informed electorate.
Representative Washington.
Thank you, Madam Chair. With regards to the Judicial Nominating Commission, I like the merit selection process, but I'm wondering about the balance of 3 members being selected by the Wyoming Bar Association and 3 being appointed by the governor. Is there significance to that 3 and 3, or might there be other models out there in terms of who composes and where do they get their seats? I've heard discussion about potential conflict with the Bar Association having such influence over judicial appointments. And might there be some other model for composing of a judicial nominating commission?
I have heard none of those complaints. Representative Washington. Justice Fox.
Madam Chair, Representative Washington, I'm sure it could be structured a variety of ways. This plan is based on what's referred to as the Missouri Plan, which was popular in the 70s, and the number of states adopted it. I think the standard has been this 3 and 3. And I, to my knowledge, it has worked pretty well in Wyoming. So I don't know of a different structure for merit selection.
Co-Chairman Olson.
Madam Chairman, Justice Fox, I'm curious on the mandatory retirement. I think that went into effect in 2007. And I know it's kind of a policy question, but I'm actually curious how you feel it's working since 2007. What is it? What is it done for Wyoming since then?
Justice Fox.
Madam Chair, Co-Chair Olson. I thought that it had been in place when they adopted merit selection and that whole system in 1972. I could be wrong. I do believe that what we refer to as statutory senility does deprive the state of good judges. Justice Davis, Chief Justice Davis, for example, still has all his marbles. And I think he would stick around. And even if he's lost a few, he still has plenty of them. And so, maybe we could have had him for a few more years. On the other hand, it does make room for new people to come up. We don't have situations like in the federal courts where people, there is no retirement. It's a lifetime appointment in the federal system, and that isn't always a good thing. So I think some mandatory retirement age is maybe a good idea. 70, the older I get, seems really young.
Thank you. And Madam Chairman, I think I was mistaken on the year. I was looking at the statute and that was a time that it was amended. It looks like for something else, maybe salary on retirement or something, but that's
Representative,
helpful. Thank you.
Representative Provenza?
Thank you, Madam Chair. Just a follow-up question with that. Do we know, Justice Fox, what kind of the average age is of a Supreme Court justice when they're coming in? How much time do they get to serve, and do we get to keep some of that seniority and knowledge gained over time?
Justice Fox?
Madam Chair, Representative Provenza, that is a concern, actually. I don't know the exact average age. I do know that I was appointed when I was 58, and that seems to be kind of the sweet spot, late 50s. And so what that means is there's a complete turnover. So I've been on the bench now 7 years, and when Chief Justice Davis retires, I'll be the old guy. And I think a little more continuity would be better.
Co-chairman?
Madam Chairman, Justice Fox, is there something in statute or in the Constitution for a removal mechanism of a justice if the justice were to, in his or her seat, reach a state of incompetence?
Madam Chair, Co-Chair Olson, in the Constitution, the Commission on Judicial Conduct and Ethics is established, and that commission would look at issues like that of competence.
So, Madam Chairman, then, okay, so I don't know that, I guess I'd have to look at the history on this age, but it sounds like there's another mechanism to address other than just a mandatory age, is what you're saying.
Madam Chair, Co-Chair Olson, you mean if we reach senility before 70, you could get rid of us?
Yeah, that's helpful to know, Madam Chairman. But what I meant was if there were not an age requirement, say, for example, if we got rid of the age requirement, we would still have a fail-safe system.
That's correct.
And Co-chairman Olson, I think that applies for all members of the bar, that if we are unfit, we can be removed or lose our licenses.
Luckily, they haven't figured that part out on my license.
I'm writing up the forms now. Representative Washit?
Thank you, Madam Chair. You mentioned the appellate process from circuit and district courts to the Wyoming Supreme Court. Where do appeals from the municipal courts go, or are there appeals from municipal court?
Chief Justice?
Madam Chair, Representative Washit, I have never seen an appeal from a municipal court. Does it go to you?
No, it goes to district.
It goes to district court.
Great questions. All right, Justice Fox, please continue.
Thank you. Next page, the Supreme Court. As Mr. Fuller mentioned, the Supreme Court has appellate jurisdiction and general superintending power over the inferior courts. We, in the Supreme Court, most of you know this, but I'm going to give you Court 101. We don't have trials. We don't have evidentiary hearings. We only hear appeals. And those are always based on something that happened in the trial courts below or an agency. I should have mentioned that agency appeals go to district court and can be appealed from there to the Supreme Court. We review records, cold records. We don't have any exciting action in our court. But we also write opinions. And so at the Supreme Court level, the legal work that we do has sort of two perspectives. And one is to get the outcome of that case right based on the facts and the law. But the other is to make sure that in doing that, we're writing opinions which help establish the law and give guidance to practicing attorneys going forward. So we're taking the short view and the long view in the work that we do, which is different than the trial courts, where getting the job done is a higher priority. Getting it done right but it's for that single case more than it's for creating a body of law. So that's the philosophical difference where we come from in an appellate court. We also do, and no one told me this before I came to the Supreme Court. I did not realize how much administrative work there was. And so when you talk about unified courts, I think in many practical senses, we are a unified court. Our administrative staff provides support with budgeting, HR, and especially IT to all the other courts throughout the state. They do work very closely with the clerks, and they have, Senator Cole, they have overcome the obstacles for e-filing in terms of sort of elected officials and court administration. There is a plan and it's running smoothly, and it's running smoothly because of the collaboration between the various stakeholders. It's been cumbersome at times. I think it would be a lot easier if Chief Justice Davis could have just said, I'm cracking the whip and here's how we're going to do it. But I think the product in the end is going to be more workable because of the process that we've gone through. Each of the justices is involved in some significant project. As the chief mentioned, I've worked a lot on Chancery Court. I'm chair of the Wyoming Rules of Civil Procedure Committee. I don't know what else. The chief has really spearheaded e-filing. Justice Boomgarden has, as the co-chairs know, been very active in access to justice and Equal Justice Wyoming projects. Justice Couts is offering to give you law school for legislators. So there are a lot of committees. There's a lot of work to be done. Other state courts have administrative staffs that are in the hundreds, when we have about 30, and they're working very hard. And all the judges are also working hard doing a lot of these administrative things.
Justice Fox, do you think that administrative load interferes with the primary mission of writing opinions and creating a body of law?
Madam Chair, sometimes I think so. Like right now, when I should be back there finishing that opinion. But overall, I think it's manageable, and I think it's important because I do believe that we have an important function in administering the Wyoming judicial branch. And so as long as we can do both those things and get our opinion work done, which I think we can, I think it works.
Justice Fox, how many employees are in the Wyoming judicial branch under the Supreme Court?
So our admin staff, Madam Chair, is 31.5. That's not counting the clerks of circuit court who are judicial branch employees. And it's funny you should ask this. We have 123 positions in circuit court, 113 full-time, some part-time in the clerks' offices throughout the state. Moving on to the district courts. District courts, courts of general jurisdiction. That means they have jurisdiction over the case unless the legislature has given it to another court, which the legislature did when it established circuit courts. They also have appellate jurisdiction, so for appeals from circuit courts, or as I said, appeals from administrative decisions. The district courts, well, all our courts are really busy. The district courts, as Mr. Fuller mentioned, are free of administrative and fiscal control by the Supreme Court, according to Wyoming statute. And each district court judge is a separate agency for budget purposes. The reality is that our financial people prepare their budgets for them and help them with HR and provide the support that district courts need. Each district court judge has a staff of 3, and that's a judicial assistant, a law clerk to help with research and writing, and a court reporter. The clerks of district court are the elected officials, and so we don't consider them employees of the branch. So the district court budgets are pretty small. Really, they just consist of the 4 people. They're housed in county buildings, so there's no real estate at issue, at least from the judicial branch's perspective.
Hey, Madam Chair. Justice Fox, just a quick question on jurisdiction and general jurisdiction. Normally misdemeanor crimes go to the circuit courts and felony crimes go to the district courts. In a case where we had both a single defendant charged with both misdemeanors and felonies, would the district court hear all of those charges under general jurisdiction? Or would we have 2 separate trial proceedings, one in circuit court for the misdemeanors and one in district court for the felonies?
Justice Fox?
Madam Chair, Representative Washit, that would go to district court and you would not split those cases. And so if there's a felony, it will be in district court. And if there's a civil matter over $50,000, it will be in district court. Also marital dissolution, probate cases, and the district court judges sit as juvenile court judges. And we don't have, like they have in many states, dedicated juvenile court judges. It might not be a bad idea to have that specialization, but as with many things in Wyoming, we don't have the volume really to justify that.
Justice Fox, with the recent learning curve associated with kind of remote courtroom appearances and remote courtroom, practices, operations, is that more of a reality now than it has been? If it was a primary juvenile court judge that was maybe located in a different area and those cases could be seen through that judge on a more statewide system, perhaps?
Madam Chair, that is certainly something that we could consider and look at. There have been different ideas tossed around on that. For example, in the districts with more than one judge, maybe to have one dedicated to juvenile cases. There are different options for approaching that, and perhaps with our remote technology, there are more options. It's something that we'll keep talking about.
Co-Chairman Olson?
Yeah, thank you, Madam Chairman. Justice Fox, I was just scrolling ahead in your presentation and looking at the case loads by type. And, obviously you're aware of this, but it's, like 70% of the docket is actually in the family world, the domestics. It would seem to me if you were going to create a specialized judge, if you were to do that, you would carve out a huge portion of the district court judge docket and actually free up their time for juvenile cases. Maybe that, what are your thoughts on something like that?
Justice Fox?
Madam Chair, Co-Chair Olson, it's true that domestic cases are a big chunk of dockets, and that is one way. Again, in other states where they have greater volume, where they have a dedicated judge for those kinds of cases, that's another possibility. Honestly, though, if you ever ask any judge I know if they'd want that docket, it could be a problem.
Good point.
That's a good point. Representative Washit?
Thank you, Madam Chair. Justice Fox, we've had this discussion about judicial workload multiple times in my brief tenure on Judiciary Committee. And one of my concerns has always been that when we're sharing district court judges from one jurisdiction to another, from one district to another, just to manage workload, that district court judge, let's say from Johnson County, who goes to Campbell County and works some cases over there, that district court judge is not voted upon by the people of Campbell County at the vote of retention. Do you see any issue there when we give the voters that choice to retain or not retain, but then we're sharing judicial assets across jurisdictions and districts?
Chief Justice?
Madam Chair, not chief yet. I'm Representative Washit. Conceivably, I guess that could create a problem. Here's the issue. We have really tried to, and I shouldn't say we, because each conference has managed this on their own, but they share the work and allocate, for example, a judge in Buffalo who might go do work in Gillette. And that's a great thing because it helps everyone get their work done throughout the state. It's true that the people of Gillette would not have the opportunity to vote on that judge if he wasn't their district judge. And I would say the benefits outweigh the risk.
Judge Christensen?
Well, I was trying to pass on. Okay. Madam Chairman and Representative Washit, we've had that discussion before, but if you didn't have that judge going from Buffalo, you'd be hiring a magistrate and you'd have the same issue because of the workload. Gillette would need more judicial people covering their cases. So in that case, you would still have a magistrate that's not reviewed for retention.
All right, any additional questions at this point? All right, Justice Fox, please, Representative Donato?
Since magistrates were brought up, I just have questions. So magistrates, if you're full-time, and I think we have 4, my ultimate question is, what's the difference in your mind between a circuit court judge and a circuit court magistrate besides the pay band?
Judge Christensen?
Thank you, Madam Chairman, and Representative Zwicker. Magistrates, in a general sense, are to help cover for when your judge is unavailable. So in the circuit court bench, it primarily was when a circuit court judge was not available, they would have a magistrate fill in for them. Now with technology, we have really significantly cut our part-time magistrate budget when we were looking at budget cuts a year ago, and with the increase of technology, the use of audio and video technology for hearings. Just an example, we recently had a judge whose mother had a significant medical issue on a weekend. Her cases were all covered on Monday through Thursday by judges around the state. We were able to do that. For our court here, there's 3 of us. We had one of our judges have back surgery out for a month. I don't know if anybody knew it. We had a judge cover video hearings for us when needed. So we are getting to the point we do not really need magistrates. It's going to depend on workload though and how that changes and stuff. Okay, when the circuit court judge positions were created, there were 6 full-time benefit magistrates in the 6 counties that did not receive circuit judges. 2 of those have left, are no longer there. it's been a determination that they were not needed and they're covered by circuit court judges in accompanying counties. There are 4 left, and those are what we call full-time benefit magistrates. That would, the only way to have them removed is by them retiring and the Supreme Court then reviewing if that position is necessary, or by the circuit court judges in that district writing a termination for that position based upon that they no longer being there, but it has to be by those circuit court judges.
So Madam Chairman, my question ultimately, we have 4 of them full-time. Is there any difference in cases they can hear, work they can do, specialization they have? Any difference between those 4 full-time magistrates and a circuit court judge on responsibilities, purview, anything besides pay band?
Chairman Nethercott, Representative Zwanker, yes, they are specific to that county, where the judges that oversee them are in other counties, and that those circuit court judges have oversight of them, which means they may also, the circuit court judges will be coming from the other county, usually doing contested cases. And so you see the judges in that district that are mainly doing work in that county as well.
All right, any final questions? Senator Kolb.
Thank you, Chairman Nethercott. Justice Fox, I had a question about the number of justices in the Supreme Court. What is your opinion about 5? And would 3 work? Do you need 7? Just a general, I guess, question about what you think your body is and how it functions. Thank you, Madam Chair.
Justice Fox.
Madam Chair, Senator Kolb, I think 5 is just right. I believe, as I was saying to Chairman Nethercott, we managed to do our administrative work as well as our opinion writing. I believe too that the nature of our work requires a little more contemplation than what the trial court judges have. And we have enough time to, you can find me staring out the window trying to think of something. We have the ability to do that. At the same time, I don't think we have any fat in our court. So I think 5 is a good number. We started out with 3. I mean, historically, way back when. Then they went to 4, which is a very bad number because you can't have any ties. You know, that just doesn't work. So 5 is good. Most states have 7 or even 9. We don't need 7. We sure don't need 9. And I kind of like 5. I think that there's a dynamic with the number 5 that we work really well together and without clicking out, you know, and I think at some point, maybe 7 and 9, you do that. So I think it's a good number.
Co-Chairman Olson.
Yes, thank you, Madam Chairman. On the topic of unified courts, I do have a question. I'm just trying, I'm maybe moving ahead in your presentation here, but so to sum it up, the circuit courts are under the fiscal and administration of the Supreme Court. The 31.5 IT, or not IT, 31.5 staff that you referenced provide services to the circuit court. The district courts are not under the fiscal or general administration of the Supreme Court. So in the theory of a unified court system, they would be. So my question is, and maybe this is partly for the district court, so maybe Judge Rogers may have to come up and opine a little on this, but I'm curious on how that works for the district court conference, administrative wise, and then also how it works for the Supreme Court in terms of, you know, we're talking about the strain on administration versus the time and ability to devote to cases. Does that work well? Would it work better with a system that that could provide more administrative support to the district court conferences? Do they, I don't know what their staff look like. Maybe that's where Judge Rogers opines. I know each, or Judge Wilkin, who you're the conference. Yeah, sorry.
So
She was
members,
just in my line of sight, but so anyone can opine on that.
so members of the committee, just as a point of clarification too, for members of the audience that might be watching, we do have with us the district court judges, and they have a conference, and their chair or their president of their conferences is Judge Wilking here from Natrona County, and she is sitting in the right of the room. And then we have Laramie County District Court Judge Rogers, who of course Chairman Olson and I are familiar with. Welcome, Judge Wilking and Judge Rogers. We look forward to hearing from you. Justice Fox.
Madam Chair, Co-Chair Olson, I'm sure that the district court judges will want to respond to that question, but I would say, first of all, the district court conference has no staff. And so to the extent that they need support for the various things that you need support for, other than their chamber staff, which is a different thing, our admin staff provides it. So whether you want to call it unified or not, the work is all being done, the budget work, HR advice if they want it. Definitely the IT work is all being provided by our Supreme Court administration staff. And in fact, the IT work is statutorily put as a Supreme Court responsibility for all the courts. And that makes sense, of course, because we need it to be uniform. So as a practical matter, the district courts have a certain amount of autonomy, certainly in their legal work. As judges, they make the decisions that they make. And to an extent, I guess, they have autonomy on their budgets, but our financial officer helps create them. And so because of that reality, I'm not sure an actual unified court district would be that different as a practical matter. Also, what I've seen since I've been on the court, and especially with all the work that we've done with e-filing, because we've had to do this in conjunction with all the judges, we have a number of really hardworking committees that include district court, circuit court judges, and clerks of both levels of court. We work together. We have to work together. During COVID, we had weekly meetings, the Chief Justice and I, Judge Wilking and Judge Christensen, just to keep on top of how we could keep running the judiciary through COVID. And in the course of those meetings, in some ways, those became a really good mechanism of governance of the branch throughout. So we seem to manage. Also, I should mention, and it's not in these materials, but we do have a Board of Judicial Policy and Administration, which is composed of 3 Supreme Court justices, 3 district court judges, 3 circuit court judges. We meet quarterly. That board makes the sort of bigger administrative decisions for the branch. And I don't know, should we, Judge Wilking, did you want to weigh in on this?
Well, so committee members, I like to keep a tight ship. And so it is 10:30 right now, which is the time that we should be moving on to our next. So what I'm going to do is have Justice Fox complete her presentation. We do have time though, and so we'll hear from the district court judges here upon the completion of Justice Fox's presentation. All right, and so we'll just be mindful of time.
All right, Chancery Court. We've already talked about this a little bit, so I won't take too much time. Another court of limited jurisdiction to deal with complex business cases in general. There's a whole category of cases. This court will have concurrent jurisdiction with the district courts, which means if you have a contract dispute that's over $50,000, you could file that complaint either in district court or in Chancery Court. If you file it in Chancery Court, you're not going to get a jury and you're going to have a rocket docket. The goal is disposition in 150 days. Right now, we have a panel of 3 sitting district court judges who will act as Chancery Court judges. And the legislation as it stands currently is to provide for a full-time appointed Chancery Court judge in March of 2023. And depending on the number of filings, we think that these 3 district court judges can probably manage this, but it does add to the caseload for the entire district court conference because they'll redistribute work to accommodate the work that these 3 guys are doing on Chancery Court. Okay. Circuit Court. I have the expert sitting here beside me. And we've talked about their jurisdiction, misdemeanor cases, civil cases under 50,000. They do a lot of collection cases. They also issue warrants, which means that these are the people who get the phone call at midnight. And they are supervised. Their employees, the clerks' employees are employees of the judicial branch who are supervised by our admin. And circuit courts, because they're a creature of statute as opposed to constitution, are set up to be supervised by the Supreme Court. Anything else?
We do Madam Chair, also we do the direct supervision of the circuit court clerks. Unlike the district court judges do not have direct supervision of hiring and firing because they're elected officials. We do have the hiring and firing ability on our circuit court clerks.
And so Judge Christensen, since you have supervisory or directive authority over the clerks, that's important to you because those are your court files, right? Those are the files that you're making decisions on.
Thank you, Madam Chairman. Yes, that plus one of the big things is making sure everybody works well together. It's hard to be hiring people for some other place when, and then put them in there and then you can't do anything about it. But we've become pretty good at hiring clerks and as circuit court judges.
Do you know the history, either of you, as to why the clerks are separate and apart from the district courts themselves? Is that a separation of powers issue, or is that just the way it was? Does anyone know?
Madam Chair, I think that is lost in time unless, I know Diane Sanchez is on the line and she may have better information than I do about how this came about. Or Tina Wood, do you know? Yeah, it's constitutional.
That they're elected, but the rationale behind that is not understood. Okay. Mr. Fuller, do you know?
Not off the top. I think I'd have to go back to the constitutional debates if it's there.
Do you want to? Don't worry, not an ask. All right, thank you. Please proceed.
Okay, so that's the court system essentially. Now, weighted workload studies, we added to the end of this presentation. This is the thing everybody wants is data, right? So how can we measure the work that the courts are doing? How can we come to the legislature and justify perhaps a request for a new judge? So what we've done since 1999 is what we call these weighted workload studies. So it starts with a very in-depth study of what the judges are actually doing in a particular case. So they have to keep track of their time. And so then you can figure out that a felony case takes 22 hours, and don't hold me to that, I just made it up. Whereas a traffic case takes 2 hours. And then each case is given that weight, and then dockets can be evaluated from year to year to see what the load is on a particular court. So the next page shows our district court filings statewide. I really am going to ignore 2020 because that's an aberration. If you look at just down the column for fiscal year 2019, you could see, let's see, marriage dissolution, number of filings is 2,578. The case weight given to it is in the blue column, that would be 70. So just based on the number of marriage dissolution filings, you can add up the caseload for that type of case and then add up for every type of case in a particular district. It's not foolproof, but at least it's a standardized measurement system that gives us some basis for making decisions. What you'll see on the district court page, if you look at the bottom there in the green, in the judicial need row, for fiscal year 2016, it was 27.5. At 2019, 28. So that means we needed 28 judges in 2019. We have 24. And now, of course, we've added Chancery Court. So, and that doesn't figure in here because we haven't done it yet. So you see kind of how this works. We will do one final workload study for district courts for, I think, at the end of June is when we'll start. Yeah. And then we'll stop because we're going to be doing this transition that we've talked to you about to full court enterprise. So we'll have a whole new system. So we'll have a little gap of a few years with no weighted workload study till we're up to speed again in the new system.
Justice Fox, for a point of clarity, I hope I'm not being annoying here, committee, but just draw your attention to this chart. Some key data points for us to consider. Juvenile delinquency chins. It provides some of that information there for how many were filed. And so I think that can be a very useful tool for us in understanding those pieces. Also, as it related to our Title 25 conversation yesterday, is that last row for mental health filings. So a pretty high number there of mental health filings to understand how significant that Title 25 issue might be. Representative Washit.
Thank you, Madam Chair. Justice Fox, you mentioned that the Chancery Court is going to have concurrent jurisdiction with the district court. Is it anticipated that there will be additional filings occurring because the Chancery Court exists, or will there simply be cases that used to be filed in district court that are now shifted into the Chancery Court?
Madam Chair, Representative Washit, we don't know for sure till it happens. I believe the vision of the legislators who were behind this, and I think your chairman can talk a little more about this, is that Chancery Court will draw more filings, that they will be in addition to the current caseload because it's all part of the blockchain revolution. So, and Representative Yin probably can speak to that as well, but we'll see. I think some cases that are currently being filed in district court will end up in Chancery Court, but also there will be new cases. Moving on then to the workload study for circuit court. You'll see we have no data now for 2019. That's because we have transitioned to full court enterprise, and that was occurring we're finished now, so we're all up to speed in full court enterprise. And once we have enough, a year's worth of filings, we'll start again. But we'll have to create the foundation for the workload study, which is, all the homework and the timekeeping, because we're tracking cases in a different way in the new system. So we need money. We need an appropriation to get the study done for the new caseload studies for circuit court, and then we'll need it again for district court when we get ready for that. But you see, the numbers in circuit court are much, much higher than in district court. The volume in circuit court is pretty amazing. They're, for lack of a better word, typically smaller cases, but there's a constant stream of them and they have to be managed, and they do it very efficiently. And Madam Chairman, you asked about what possibilities there are now with our experience with remote hearings. Their ability to cover for each other has really been multiplied during COVID because of, first of all, because of the great equipment that we have, and second of all, because of the need. And so I think they're even more efficient than ever.
We'll have a question from Representative Washit.
Thank you, Madam Chair. Justice Fox, when I look at these FTE needs, and there's a difference of 3 between the approved staff and what we have available. And I'm wondering, when we divide that statewide, is there a full judge needed in any particular circuit? Or is it a situation where we need 1/3 of a judge more in this circuit and 1/3 of a judge more in that circuit?
Madam Chair, Representative Washington, I may let Judge Christensen respond to that, but I think it is a part of a judge that we're talking about.
Judge Christensen?
Madam Chair and Representative Washit, that is correct. It's like we review this quite a bit, especially with technology. Where would we need a judge, and where might we need less of a judge? I think it's allocation, and it's been assisted with technology, has helped us out a lot with you can have a judge across the state, like we've already talked about, covering for a judge in the other part of the state. So it's worked very well. I couldn't say we need maybe a reallocation, but I don't think we need a new circuit court judge at this point.
Justice Fox?
Thank you. So that's a really quick summary of our system. It may seem a little cobbled together at times, but it actually works really well. It has been tested in the last year, and I think works even better since we've really had to pitch in together through COVID. So yeah, if there are no more questions, that's all I have for you.
All right, committee final questions for Justice Fox. If not, we'll move to the district court judges, Judge Wilking, and also Laramie County District Court Clerk Sanchez, who is appearing with us via Zoom. So with that, we'll welcome Judge Wilking. Committee, once we're finished with Judge Wilking and District Court Clerk Sanchez, we'll review the testimony and then probably take a quick break and then move to our next topic. Mr. Fuller?
Yes, Madam Chairman, just to follow up to your question earlier, South Dakota was by constitutional amendment in 1972. Alaska, I could find no constitutional amendments. Theirs was ratified in 1959. So I believe their court has been unified for the entirety of their statehood.
Wonderful. Thank you, Mr. Fuller. Welcome, Judge Wilking. Good to see you again. Good to see you live. I think most of the committee has seen you on Zoom. So welcome. If you would introduce yourself for the public that's watching.
Thank you. Good morning, Chairman Nethercott, Co-Chairman Olson, members of the committee. My name is Catherine Wilking, and I am a district court judge here in Natrona County and the current chair of the District Court Conference until September, when we will elect a new chair. I appreciate the opportunity to speak with you. I so appreciate that we're here together in person instead of you all being in little squares. I'll just touch on a few points. I know you're crunched for time and I appreciate that. The district courts, we do have 24 judges. That is outlined in statute 53101A. I was looking at the numbers of cases filed, and I will just say something about data, sorry. But there is data on the Wyoming Supreme Court website, and I've been poring over it, really trying to get prepared for this hearing. It goes all the way back to 2007, and you can look at that, and it breaks it out by case type, by number, and by district. And so that was helpful for me to look at when I was looking at the DFS numbers in that report. So I invite you to look at that if you haven't previously. When you look at the case numbers, really from 2016 to present, we average almost 18,000 cases a year, a little bit under that. It's important to remember in district court cases, that's just a filing in a fiscal year. That does not mean that that case will be resolved in a year. We are much different than circuit courts. Judge Christensen talked about their ability to cover for one another. They can cover a case that will be then disposed of in an hour. And in district court, those cases can go on for years. And so I think that's important to remember when you're looking at those numbers. Wyoming Statute 53106 does provide and allow us to hold court for one another across the state. And we do that routinely. That's been discussed a little bit previously. We do take case assignments from one another upon request. If a judge has a conflict, they will put out the word, I need to assign a case because I, as the judge, have a conflict. The attorneys on the committee know that you can also peremptorily disqualify a judge. You can just say, I don't want that judge to hear this case. And so if you're challenged for cause, you need to assign that case out. Also, we have to assign cases when we can't get them scheduled within the time that they're to be heard because our dockets are too busy. I did a quick little poll of our conference members to say, just in the past 2 years, can you give me an idea of the number of cases that you've accepted on assignment for other DJs? At the lower end, it was 10 cases. At the very high end, we have judges that have taken 24 cases in the past 2 years from our colleagues. These are not simple cases. They're often very complex cases that are being referred out. They can take well over a year to get ready to go to trial. And then most of the time, they're a couple of weeks to try that case. When you do take a case on assignment, you do actually have to try the case where it was filed. So if I take a Laramie case, I'm going to be traveling to Laramie in September, actually, to hear a case in Laramie. The DJ who needs to assign the case routinely will just send out an email. And I would say within 15 minutes, they've got several responses and their colleagues are offering to take that case from them. It's even easier now with the technology because we can do pre-trial matters using the video technology as long as the parties agree. There are some that do not agree to do it that way, and so we'll travel for pre-trial hearings to the jurisdiction where the case was filed. When I was looking at the numbers, it's striking that the case numbers are fairly consistent for the numbers that are filed every year in district court. What's changed is the amount of work involved. And these cases and the litigants are requiring more and more time of the district court judges. As an example, in juvenile court, let's say you have an abuse or a neglect case and the prosecutors will be familiar with this. It's becoming a very specialized area of practice for attorneys. You've got parent attorneys, guardian ad litems, who, to their credit, are doing really good jobs for their clients. And so, whereas before we would never have a pretrial motion practice in juvenile court, that's becoming the norm. It was unheard of to have jury trials in juvenile court. That is now also becoming the norm. And sometimes we will get rulings from the Supreme Court that also change the practice in juvenile court now. If you are a parent and you have a case plan that says we're going to reunify your child with you, if there is during the court hearing a recommendation from the MDT team that we're going to change the permanency plan and now we're not going to reunify with you with your child, you are now entitled to a full-on contested evidentiary hearing before any change in permanency can be made. I personally think that's a good thing because it's a fundamental parental right that's at risk there. But it has changed the way that we have to do juvenile court and the time we have to devote to it. Another thing that the attorneys on the committee will be well aware of, there's been a change in Wyoming as far as who can practice in Wyoming and the licensing requirements. That has really opened up our state to a lot of out-of-state attorneys who are now developing active practices in Wyoming. I don't need to tell you that people do things differently than Wyoming does. I think we do it the best. I think most of the time our attorneys are very civil with one another and they're able to work out their disputes amicably. That isn't happening with some of these out-of-state attorneys. And some of the younger members of the bar could perhaps use some lessons on being civil with their colleagues. So those matters that are not being resolved, discovery disputes, things like that, we're seeing those more and more and more. So those take more time. And then self-represented litigants are becoming much more common in district court. I've said this before, the forms that are available have been a blessing and a curse to the courts. If you have an agreed upon divorce, you agree on custody, you agree on property division, you can fill out one of those forms. You don't need a lawyer. The judge will likely sign off on your decree. But that also has given folks the impression that I can just fill out this form and I will get whatever I want from the judge because I filled out the form. They don't comply with the rules of procedure. They don't comply with the law. And it's even gotten to the point now where folks think that they can handle very complex probate matters by themselves just by using these forms. So the amount of time that district court judges are communicating with self-represented litigants by letter, that's your first attempt. But then we're having hearings with them multiple times to try to explain process and procedure just to get them to be ready to have a trial. And unless and until you have seen a self-represented litigant civil trial, I cannot explain that to you. It is something to behold. I think lawyers have been maybe on the other side of that. And it's something that we have to do. It is our responsibility and we try to do it well, but it does take a lot of time. So the work has changed and it's requiring more time and effort from the district court judges. Justice Fox mentioned the committees. I've given you that list of committees that DJs serve on. It's extensive. There's a lot of work being done. And at on some committees, there's a requirement that you have 3 district court judges on a committee. But I agree with Justice Fox. It's important to have DJs be a part of that. But just do recognize that's work that's on top of their regular dockets. So all of that requires us to implement a lot of efficiency measures. In the 7th Judicial District, we routinely we enter time management orders in cases. So the parties will request a trial or a hearing, and my judicial assistant will call and say, counsel, you said that you need 2 hours for this hearing, but I called the other attorney and they say, no, we need 3 hours for this hearing. Well, I will set it for 3 hours, but I will enter a time management order that divides to the minute the amount of time each side has to do their presentation. It keeps everything on track because quite frankly, gone are the days when you could have a trial setting for a Tuesday and you didn't get it done all that you needed on that Tuesday, and we just carried it over to Wednesday. Those days don't exist anymore because I will have something else set for Wednesday. So we have to have those orders in place. I had a 10-day medical malpractice trial that had a time management order in place, and we hold them to it, and it does keep us efficient and running. The state bar just put out their attorney satisfaction survey results, and I was looking at those, and there were several comments lamenting the fact that the courts are focused so much on efficiencies. And I understand that, but it's really done out of necessity to get our work done. Just to touch on the unified court discussion and the BJPA, I think that the BJPA is important for you to understand. That was created by both of Wyoming's constitutional courts. So it was created by agreement with the Supreme Court and the district courts. It's been in place since the Supreme Court order was entered on May 24th of 2000. So it's been in place for a long time. And in that Supreme Court order, the superintending authority that was vested in the Wyoming Supreme Court by Article 5, Section 2 of the Wyoming Constitution was delegated by the Supreme Court to the BJPA. And then in June of 2001, the District Court Conference unanimously agreed to delegate their administrative authority under Article 5 of the Constitution to the BJPA, with the exception of the budget submissions that have been touched upon. So we all agreed 20 years ago that the BJPA would be the governing authority for those constitutional courts. And these are on the website as well, the rules for the BJPA. If you look at Rule 3, it provides that the board will exercise general superintending control over the judicial department for administrative, policymaking, and planning purposes. So you've got 3 Supreme Court judges, 3 DJs, and 3 circuit court judges that make up that board. And it works very, very well. As Justice Fox mentioned, that's been proven over the past year. And so we have that system in place. So if there were concerns about how courts are operating or changes that were suggested, that board is there and has the authority to act. Justice Fox
Judge
is,
Wilking,
yes.
just briefly, real fast. Those are for all the judges. What about the role of the district court clerks with that?
Chairman Nethercutt, the Board of Judicial Policy and Administration, to my knowledge, has no authority over the clerks of district court. They are provided for in the Constitution that they are elected officials. And I can just relate to you, we now have a new district court clerk, but one that had been there for many, many years, always used to say to me, public money is public trust, and that's why our system is as it is. District court clerks are very different from circuit court clerks just because of the complexity of the cases that they have to administer. But the district courts and the Supreme Court don't have any authority over them. I would say, just looking at the rollout of the case management system and the clerks being involved on all these various committees to get that going, they do work collaboratively. And I think if they didn't, we wouldn't be able to get these things in place. So the BJPA might be able to make recommendations, but wouldn't have any actual authority over them.
Senator Cole?
Thank you, Co-Chair Nethercutt. Judge, question, acronyms. Would you please say the thing you're associating the acronym with, BJPA, for myself and probably the audience, just if I help me out a bit. Thank you.
Chairman Nethercott, Senator Kolb, thank you. We do take it for granted when we throw those around. It is the Board of Judicial Policy and Administration.
Any final questions? Co-Chairman Olson?
Thank you, Co-Chairman. On the topic of data. Okay. So actually super fascinating that your observation that it really is, no matter what case type you look at on the district courts, it's really steady, which is actually pretty perplexing because death hasn't gone up, divorce hasn't gone up, crime apparently hasn't gone up. Everything's just the way it was in 2016. But my question is, and this could be for whoever, manages this data, but on the topic of pro se litigants, I'm curious if we have the ability to pull that out of this data. So when we look at 2,600 marriage dissolution cases, how many were pro se? Can we do that?
Judge Wilking?
Senator Nethercott, Co-Chairman Olson, I believe that the way that Y-User is set up, and if the inputs are correct, you can run a search to figure out if a party is represented or not. And I do believe that the Access to Justice folks and like organizations do keep data on how many self-represented litigants you have, not only in divorce cases, but many other cases.
And everything. Yeah, I'd be curious to see it in everything across the board. So I'll probably just follow up with them on that.
Representative Rodriguez Williams.
Thank you, Madam Chair. Your Honor, just a brief question regarding traveling to cover for other judges. You stated that you're taking a case in Laramie. Who foots the bill for that? Does Laramie cover your travel or does your department?
Judge Wilking?
Chairman Nethercott, Representative Rodriguez Williams, for everything that would be done pre-trial. So if I'm doing those things by video, there's no cost to the other jurisdiction. But I do have the option if I wanted to, that when I traveled to Laramie, because that will usually mean my court reporter will come with me and you have lodging and things like that, that judge would pay for that out of their budget. However, if, we converse among ourselves. And so if that judge were to say, I don't have any money in my budget for that, I would say, well, I'll use that out of my budget. Or we do have the ability cross jurisdictions and our budgets to say, let's say Teton County has used all of that money. Does somebody have some that can be placed in their coffers?
All right, thank you, Judge Wilking. Any final comments?
I would just say, and Justice Fox, I did want to correct one thing, and this is important, and with all due respect to Judge Christensen, there are a lot of differences between circuit court and district court. So for that judge that is covering child support and other cases for Campbell County, if that judge wasn't doing that, I highly doubt there would be a magistrate hired, because that would have to come out of that district court jurisdiction's budget, and nobody has money to hire magistrates. So those judges would just have to do that work if that other judge was not covering for them. The weighted caseload studies do show we need new judges. I have told you that every time that we've met. I know that's difficult to deal with. And I know that maybe you're going to look at a better way or a framework for deciding when another judge should be allocated to a jurisdiction. The Chancery Court, us taking on that work is going to be difficult because we will have to cover other cases for those judges. It's not that we're just busy and we're complaining about that. We are very busy, but the impact that it has on your constituents and the citizens of Wyoming is significant. If you can't get your divorce case heard in a really busy jurisdiction for a year, that's unacceptable. But we only have so many judges and we only have so much time on our docket. So it's not just that we want to have additional judges. Citizens deserve more timely justice than we're able to give them. And I know you want to have a better framework for that. I will just say in closing that we did amazing work. The Wyoming Judiciary did amazing work during the pandemic, and that work continues. It does feel like we're being tasked with doing more and more with fewer and fewer resources. Each time the legislature meets, it's likely you will pass a new law or you will change existing laws that will have work coming to the judiciary. We're always appreciative when you take that into consideration during your discussions for bills, but I don't know how appropriate it is for you to be saying, well, this is a really good bill, but we don't have enough resources in the judiciary to have it passed. I don't think that keeps you from passing laws, but when you pass them, you expect them to be enforced, and that is our charge. And all we're asking for is that we have enough judges to do it. Thank you.
Judge Wilking, a couple questions. Do you feel like you have an appropriate amount of staff, or could you use more? And would that help with time or efficiency, like another law clerk? Just some other options to consider.
Chairman Nethercott, I feel that the district courts have sufficient staff. Justice Fox is absolutely right. The Supreme Court provides budget support, human resource support, IT support. They are there for us just with a phone call. And so we don't have to worry about those sorts of things. It really is just the volume of cases. And, you know, if I had another staff attorney, perhaps that would be helpful, but that attorney can't do the actual court for me. I've got to have my rear end in that seat.
Co-Chairman Olson.
Thank you, Madam Chairman. Just want to follow up on that. So is there, in your opinion, a possible better framework for more judges other than just adding more judges? I mean, that's one possibility over the existence of Wyoming's future. We'll just continue to evaluate and add new judges, but some ideas that have been tossed around, you know, a juvenile court like the Chancery Court, where once we actually seat it with a different judge, in theory, it should reduce dockets. Juvenile judge, family judge, more districts. Is there some type of framework that we should be contemplating that may alleviate those dockets more?
Judge Wilking.
Chairman Nethercott, Co-Chairman Olson, I would tend to agree with Justice Fox. I don't know that our numbers support a specialized court like that. And I think you can look at that and make a determination. I will say that I've spoken to a lot of newer judges and this is their observation. I had no idea about, you know, this area of the law. And I think in Wyoming, I am a better judge because I preside over all of these different sorts of cases. So it's not uncommon in my jurisdiction for me to not only have the abuse neglect case involving a family, I will probably have a criminal case involving one of the parents. I'll have the child support case where they're asking for repayment for some sort of placement for the child. And, you know, you just are a better judge because you understand that families being impacted by all those aspects of the criminal justice system. So that's the best answer I can give to that.
I will provide the committee with some history on this topic. So a couple of bill drafts in the last couple of years have been moved by the committee for the creation of a new district court judge in these areas that need it. The committee has always refused to adopt that bill draft, and so it has failed in the previous committee's membership. There was also an effort to create a bill draft that would kind of adopt what the court is doing in some fashion of the weighted workload study that would require this committee to review it on some type of regular basis to evaluate the need for more judges. And the purpose of that really isn't to create another bureaucracy or another layer, but it prevents or obviates the need for the committee to make a determination for more judges and to turn it up into an interim topic, for a district court judge to have to come ask a legislator for a judge, which can sometimes be uncomfortable. When I first came onto the committee as a legislator, I didn't even know how judges were to be created by statute, what made that determination. And so upon my inquiry, it was just told that the way that the court was able to obtain more judges for the people of Wyoming was through asking very powerful key legislators to take on that legislation. And that didn't seem to sound right for me. So I wanted to create a more objective kind of long arm approach to that and prioritize this for this committee of what those workloads look like for our district court judges, ensuring that that meets the needs of the people of Wyoming. Unfortunately, that effort also failed, but certainly the issue will present itself each year to this committee because the issue is not going away. So thinking about some of those solutions as we move forward, I think is helpful. All right, any final questions for Judge Wilking? Senator Cole?
Thank you, Co-Chairman Ethicott. Judge Wilkie, you expounded on the fact that when a statutory change happens, it takes more of your time and effort. I'm curious on exactly why that is. If you could give an example, because I don't, it seems like if there's a clarification in law about a particular subject, I don't know enough about it. Could you please help me with that? Thank you. Chairman Ethicott.
Judge Wilking?
Senator Nethercott, Senator Kolb, I can give you an example. Did happen to me personally. So there was a change in law with the stand your ground law. And I was the first judge that got to address that issue. I did my level best to do that. The Supreme Court let me know I got it kind of right. But as a result of that process now, when you have someone who wants to use that defense, they are entitled to a very complex evidentiary hearing at the district court level. And so that is occurring now across the state. And so those sorts of changes just, if you're entitled to a hearing or to go before a court, that's something new that we have to address.
Follow up. I understand that, yes. But is that an exception, or is that if you have a clarification about, revenge issues with taking pictures of folks and publishing them, that didn't seem to be a big deal. But I do understand the example you did give. Yes, I do understand that. So that I just meant as a standard, statutory change, because I didn't consider it honestly until you had brought it up. So I'm trying to learn more about it, but thank you.
Representative Yin?
Thank you, Madam Chair. Judge Wilking. So I appreciate the workload, the weighted workload standards. Have we ever measured as another metric the average amount of time a particular case might sit on a docket and how that has changed over time?
Judge Wilking, if you know.
Senator Nethercott, Representative Yin, I guess I'm not clear the amount of time that a case stays on a docket, or can you clarify your question, please?
Madam Chair, if I may. So I'm new to the judiciary system, but you did mention that it would be not great if someone had to wait a year, essentially, before they could get a divorce hearing. So that's what I'm interested in, is how long it takes for the application of justice in the judiciary system. And if that has taken longer over the years, would that be a useful metric to determine whether or not we need a new judge? Thank you, Madam Chair.
Judge Wilking?
Senator Nethercott and Representative Yin, that would be a very helpful measurement. Lisa Finke with the Children's Justice Project does measure that for abuse neglect cases and reports that to us. So we know how long it takes us from a case being open till the time they reach permanency. So those pieces of data are able to be mined from Y-user. With the rollout of the new case management system, it's my understanding that that will be very easy to look at, is how long has this case been open? What is the time to final disposition? I believe you could get that information from Y-user, but as Ms. Butler mentioned, it would just take them writing the way to search for that information.
All right.
Madam Chair, I'd be
Follow.
interested in finding more about that if we could. I don't know whether it would be through Ms. Butler or maybe through LSL, but.
Ms. Butler, would this be something you could respond to? It is freezing in here. As we can see, Ms. Butler, I would concur with her nonverbal communication. I'm not sure what we're at right now. What's the current temperature? Let's bump that up to a solid 70.
I knew this would happen the moment I gave the gavel over.
I am the chairman of the day. Welcome, Ms. Butler.
Thank you, Madam Chair. I believe I forgot to introduce myself when I was speaking to you before, so I will do it now. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Supreme Court. To your question, Representative Yin, we probably could pull some of that data right now. Again, we'd want to vet it for its accuracy. There are what we call case statuses. So wherever the case is in the life of that case, there are case statuses that go along with that. Again, so we have those case statuses currently in Y-user. We have them in full court enterprise as well. They have been shifted a little bit as we move to full court enterprise, but it's another thing that we're training heavily on as we move forward with the new case management system. So I think it's possible to pull that information now. We just want to make sure that it's accurate.
All right, Representative Washut.
Thank you, Madam Chair. Judge Wilking, I want you to put your juvenile court hat on and just kind of give us your experienced wisdom about what you see in juvenile justice in Wyoming. Is the system in good shape? Are there adequate resources? Give you the floor.
Judge Wilking.
Chairman Nethercott and Representative Washut, juvenile justice has always been near and dear to my heart. I was a prosecutor in Natrona County for many, many years. I handled a lot of those cases. I was a guardian ad litem. And it's never going to be like I want it to be, the juvenile justice system. I think that there are not enough resources. I believe I can speak for the whole DJ conference. We fully support keeping children in their communities. It's just we have to have resources within the communities to service them. It used to be that you just had maybe a dirty house case that you could put some services in there and your case would be open for a few months. That's rare anymore. The issues that are being brought before juvenile court, you've got substance abuse issues with the parents, economic stressors, and then you have children that are suffering abuse and neglect. That's why they're there, but also significant mental health issues. And so all of that is being thrust into the juvenile court system to try to be resolved, and we're not the best at that. On the CHINS side of things, I agree with Director Schmidt that that is a vehicle through which folks are accessing higher level mental health care for juveniles. It's often been said in our conference that it should actually be child in need of services versus child in need of supervision. A CHINS or a PINS, which is parent in need of supervision or services. And so, when you look at the CHINS statute, it's habitually truant. They've run away. They don't follow the commands of parents or other authorities. We're getting arguments now from their attorneys that, well, judge, this child suffers from a mental illness. isn't there a volitional aspect to being a child in need of supervision? Don't you have to actually mean to disobey your parent or to act out? And if they've got a mental illness, is that really what the Chin statute's there for? So it just is overwhelming as a juvenile court judge to be presented with this menu of problems and complex issues. And then we're charged with trying to address that and solve it for these folks without a lot of resources or placements within our communities. And I'm saying that as a district court judge sitting in Natrona County, and we have resources that the rest of the state would envy. And it's difficult for me. So it doesn't look great from where I'm sitting, but I don't know what a good solution is for that.
Judge Wilking, do you think that the Chin statute needs to be reviewed by this committee to evaluate an option for children in need of services like you've identified and kind of expand the scope of the court in those extreme needs?
Chairman Nethercott, I think it would be very enlightening for you to look at that more closely. I frankly, just speaking for myself, I often feel like I'm dealing in fictions to get services for children. I think you saw in the report, Director Schmidt submitted that sometimes a kiddo will start out as a Chins, and then you turn it into a delinquency case because they didn't follow a court order, and then you place them at the boys' school or the girls' school because that's where that's your option. I just don't know that that was the intent of the legislation. And so if you want to take that on, we would appreciate it.
Yeah, committee, one of those thoughts I just have is kind of getting our arms around juvenile justice, recognizing we started the topic off very large, right? Just kind of getting our arms around it and understanding where to maybe provide some measurable outcomes for us for the interim and identify those key points that maybe need our greatest attention. And that might be it, hearing from a clear subject matter expert on the matter. So thank you, Judge Wilking. Ms. Butler, anything more from you? All right. Thank you so much. Any final questions for Judge Wilking before we get to District Court Clerk Sanchez? If we could bring her on online. Thank you so much. Welcome, Clerk Sanchez. We can see you. It's great to have you here. If you would introduce yourself to the committee and let us hear your thoughts.
Madam Chair, members of the board, thank you very much for allowing me to appear by Zoom. My name is Diane Sanchez. I am the Clerk of District Court in Laramie County. And I really just have some brief comments as to some of the discussion. One of the things that I would like to say is, as the years have progressed, so has technology, as everybody is aware, which also brings a great deal of change. So I feel like not only has the Supreme Court learned a lot through that process, but so has the clerks of district court. And so part of that, what I'm going to refer to, is with the Y-User. In 2012 is when Y-User was rolled out as a statewide case management system. Before that time, the clerks of court were on their own systems. So the possibility of collecting data was much more difficult than when, obviously, when all of us were able to be on the same system. But with that, the training that the clerks of court received was very poor. And the vendor is who did the training, and we all were trained in different ways. And so, like, an example of that, just so that you are aware of my perspective, I was not a clerk at that time. I was a deputy within the office. And when I was trained, I was told to go to a spot on the screen. My eyes do not immediately go to those spots. So I was trying to find it, and my trainer got frustrated and took the mouse out of my hand and said, it's right there. That was my training. And I feel like there was a lot of things that were left out in training between each court. So has it been a learning process to see what data needs to be gathered and to see if the clerks are all doing it the same way? It has. And I feel like even the process of us going onto full court enterprise has brought some of that to light, because we have been able to see where some differences are that we perhaps have not seen before. I do feel like all of the clerks really have worked very hard to come over some obstacles that we have had, just as Justice Fox referred to. All of us have a goal that we want our judicial system to be a strong judicial branch. So I feel like between all of the branches that we are working toward that. I feel like the training for the new case management system is going to be greater. The Supreme Court most certainly, I feel, learned from that process before. And again, it wasn't any fault of theirs because they were not involved in that. But I feel like they had learned from some of our frustrations and they've heard us, as they have a very outlined training program for each one of our courts to go through, which will be uniform. And with that in itself will bring uniformity into the courts. I also would like to just touch on some things are done different in each court. And I feel like some of the reasons for that is that our state is so sprawled out and we have such differences in sizes of counties that generates some of that. Also, we have judges in each one of our courts that perhaps might want something done a little bit different. And this is an example of something most recent that all of you will be aware of, and that is during the pandemic, a lot of the courts did start accepting emailed documents for a way of filing. And so as Rule 5 was changed, which I think was a very positive, there also still was some differences. And part of that is because of the judges. And so my example of that is there are some of the courts that are not asking for originals to follow up when we receive an email document. Other courts are, and that's based on the judges because they have requested that they have an original document in the court file. And so as clerks, even though we do not work for the district court judges, we serve them and we try to do what makes our court work the best and what we try to meet whatever their needs are. And so I guess I will stand for question with that.
Thank you, Clerk Sanchez. Questions for Clerk Sanchez? As a constant reminder, that is my law office in the background there through her window. A reminder of what's to come.
I will tell you, I have the most beautiful view of Cheyenne.
Wonderful. Thank you, Clerk Sanchez. We really appreciate you being here. All right. All right. Is there any additional public comment on this topic? Do we have anyone online? No? All right. Public comment is closed. Committee, back to you. Any action items for this? Excuse me, Representative Zwanitzer?
I'm going to have 3, Madam Chair, if that's okay. Well, even if it's not okay, I'm going to bring them.
Well, just as a point of clarification, Co-Chair or Representative Zwanitzer, I know you know this, but if you want a second, you may want to separate out the 3, but we'll give you room for the 3.
Thanks, Madam Chair. And Justice Fox will turn off that mic. Thanks. So my first motion, Madam Chairwoman, would be to have a bill drafted to add 2 new district judges. And I'm going to make the motion that we establish a family court mirrored after the Chancery Court statute that would allow petitioners to decide if they want to go directly to family court or stay in their home jurisdiction. I think that'd be the way the bill could be drafted. We could do whatever we want with it. But I do think with technology and then just the length of time for what I believe are procedurally quicker things that can take 9 months just because they're backed up on the docket, that some cases, especially divorces, may want a quicker resolution and don't want to be, constantly pushed back in the docket to get to, and they could have a choice to have a quicker resolution if we had kind of a family court structure. So that'd be my motion for my first one, if there's a second.
Is there a second? Seconded by Provenza. Discussion on the motion? Questions on the motion? Yeah, as a reminder for the committee, these are just for a bill draft. And so this is not adopting legislation. And sometimes just having a bill drafted can also generate good discussion from the public and from stakeholders. Representative Oakley.
Thank you, Madam Chairwoman. So what you're proposing, what you're envisioning is one judge for one family court that's statewide? Is that what you're asking?
Representative Swanser.
Thank you, Madam Chairman. Technically, I'm asking for two. But yeah, similar that they could be an in-person, or my optimistic hope would we could do an online, that if people want to choose an online option to go be on a Zoom hearing or whatever, we've been doing for the past year, and wanted a quicker resolution, that we would have district judges primarily dedicated to the gamut of family law issues as a quicker resolution to, as you well know, child cases always seem to take up the docket immediately. And so you're always having to schedule what I think are basic perfunctory things. But I think that's the fairest way to add 2 new district judges, because the need is there, but the need is throughout Wyoming. And whether we morph that into putting them in home districts, we could do that, because as you hear, they transfer all over the place now. But I just think it's a better way for efficiency moving forward to have those 2 extra judges, be able to space them around where there's need, and to allow the citizens who want perhaps a quicker resolution, and their attorneys in some cases, to say, this is actually the right option. We'll get it done. We'll get it done quick. They're much more complicated cases. I know Judge Wilkins said, where you have an entire family scenario of child support and custody battles and adoption, right? So not for those, but I think the need is there, and I'm trying to be the most efficient about that need. For a bill draft, we can certainly rip it up and move it around when we have something statutorily we can focus on and debate.
Representative Oakley.
Thank you, Madam Chair. And you had said, Representative, that would it be contingent, the way you're thinking of it, contingent on being willing to, it's got to be a case that could be done online, and that would be part of filing there? Is that what you're envisioning?
Representative Swanser, I think similar to the Chancery Court.
Yeah, I figured if we stretch it after the Chancery Court, that would be the most efficient way to have the bill draft. I know there's many freshmen, new people to the committee, but this is really the way is we can talk about these issues over and over, but until you have a bill draft in front of you where people can say, really should do this, or let's take out that statute, it's tough to kind of move forward. So I think the need's there. If we model it after the Chancery Court, I would imagine people could do Chancery Court online or appear in person, depending on the situation. So I thought that was just the most flexible structure to start with, but I don't have any grand envisionment of where I want it to go. I'm just trying to find a way to fit the need right now and allow this committee to pursue an option.
Are you trying to solve problems, Representative Swanser? Further discussion on the motion?
Just one thing I want to add, Co-Chairman.
Co-Chairman Olson?
I recently started engaging in this process, and I think what would be fascinating about this bill, bringing the district court, different district court judges as we have our hearings around the state to answer this one question. I started to ask district court judges how they've handled some hearings during the COVID period. And, of course, it's all over the place, but I was talking to, I think it was Judge Carell recently, who said that they were able to handle, all evidentiary matters in this digital world. And he thought it went really, really well. It doesn't mean it's always going to go really, really well, but I think it would be fascinating to have the opportunity to ask the different judges how that worked for them over the last year, and if there is some type of model going forward. And on the appellate side, I think there's been a lot of interest in attorneys who would love to, it's a little bit different, appear virtually as opposed to traveling to Cheyenne for it. But I think it could create a fascinating conversation, just adding that to learn more about how our court systems function during the COVID period.
Further discussion on the motion? Question being called. All those in favor of Representative Swanitzer's motion to have a bill draft created for the creation of a 2-judge concurrent jurisdiction family law court, please say aye.
Aye.
All those opposed?
No.
All right, the chair is in doubt. All those in favor, please raise your hands. Raise them high. And I need staff, if you can help me count. Yeah. And all opposed? Raise your hands. Looks like somebody's not voting correctly. What's the vote count?
7-6.
If I may, Senator Cooper, we didn't, okay. Okay, then with that, I have 7-7, Madam Chairman.
All right, that motion has failed. All right, committee, any further motions? Representative Swanizer?
Thanks, Madam Chairman. We didn't talk about it much today, but it was on 2 places in the materials provided. And I don't think many people in the committee know, Wyoming actually has the lowest mandatory retirement age of any state. So judges for district and our Supreme Court justices have to leave the bench at age 70. About half of the states have an age ranging from 70 to 90 in Vermont. Another half of the states don't have any mandatory retirement age. But a couple of states have in the past 5 years allowed them to finish out their judicial term. And so I would ask for a bill draft to maybe not raise the mandatory retirement age, but to allow a sitting district judge or Supreme Court justice to finish out their length of their last retention. So it'd be a 6-year block, primarily because retirement costs are huge for justices. And when you have 24 districts and the 5 Supremes and you have 1 or 2 retiring every year, because nobody comes to justice or district judge in their 20s, just financially, it's hurting our system. And so allowing them to stay in a little bit extra, I think, has multiple benefits, both to efficiencies, to the process, and to our retirement system.
Is there a second to the motion? Seconded by Senator Cost. Discussion on the motion. Representative Mr. Fuller.
Madam Chairman, I just wanted to note Article 5, Section 5, the Constitution, and just read this. The office of every such justice and judge shall become vacant when the incumbent reaches the age of 70 years, as the legislature may prescribe. But in the case of an incumbent whose term of office includes the effective date of this amendment. So that language, I think, just covers, was just a grandfather clause. But either way, I just wanted to know that this would be a constitutional amendment that would be needed.
Further discussion? All those in favor, please say aye.
Aye.
All those opposed?
No.
That motion has failed. Any additional motions? Representative Washut?
Thank you, Madam Chair. I just moved that the LSO prepare a kind of a white paper on the Chin statute, breaking it out, giving us some history, and allowing the committee then to review the Chin statute in some detail at our next meeting.
All right, we'll take that into consideration for the committee. I don't think that needs a motion or a bill draft for, we can certainly add it to a topic, which we'll certainly do as the chairman. Any additional motions for a bill draft or committee action?
Yeah.
Co-Chairman Olson?
Thank you. Co-Chairman Nethercutt, I would like to this isn't a motion, this is just a request for a bill draft. I would like to resurrect, I don't know exactly what your automated
Co-Chairman Olson would like to see on the next agenda, Mr. Fuller, the bill draft that was created from the Joint Judiciary last year at my request for doing the weighted workload study and then the review by the Judiciary Committee of the District Court judges.
We can just bring back that same bill and start from there.
Mhm. Okay. It's got that. Further actions by the committee, Representative Zwanitzer, I appreciate your work.
I feel like we should be doing something on this committee, Madam Chairman. So I make a motion to have a bill drafted for what I would call it a unified court system, which would primarily take out each district. I'm trying to think how it would primarily affect the budget, and have a unified system because we're already paying all the district judges the same. And as you heard, based on workload and caseload, they're transferring funds when they have to travel to different jurisdictions. And if we just had one pot of money that was overseen, I think it'd be more fair, equitable, and provide better access to justice. So a bill to draft on a unified court system and mirrored off of whatever the most efficient and best state out there is. Maybe it's Alaska, at LSO's discretion to find whatever the best model act is and start drafting what we would consider a unified system for Wyoming.
Is there a second? Second. Seconded by Senator Kolb. Discussion? The far right side of the room I'd be happy to hear participation from. Representative Crago.
Am I far right enough, Madam Chair?
You're right where you're supposed to be.
I guess discussion on the motion. To be honest, I didn't hear any testimony from the people who are actually the boots on the ground today, whether it be the Supreme Court, the District Court, or the District Court clerks as to the need for that particular action. And so I'll be voting against that. As someone who practices in all of the courts, whether it be municipal, circuit, district, or the Supreme Court, I think we have a really great system. We have good judges, and I think it works as it's supposed to. Thank you, Madam Chair.
We're just going to add some further discussion on that. What's interesting is I think what we heard testimony is that they are operating as if they already are a unified system, which is, I think, unique. Fun argument to present is whether or not that's contrary to state statute, which the district courts are to be free from the administrative oversight of the Supreme Court, and yet they have consented to it by virtue of their actions. Just a fun, interesting concept for everyone to consider, but certainly up to you. Further discussion on the motion? Question being called. All those in favor of Representative Zwanitzer's motion for a bill draft regarding a unified court system, please say aye.
Aye.
All those opposed, say no.
No.
All right, we're gonna have to raise our hands again. All those, please raise your hand if you're in support of the bill draft. And again, committee, it's just a bill draft. We can just cancel the second meeting. Co-Chairman Olson would like to not vote on bill drafts.
Yeah, I'd almost like to back up a little bit. I know how I chair my other committee. Bills just come out, but I think, I guess I would just kind of slow the committee down a little bit because we're voting. We are right now, what you're doing is there was 30 seconds of discussion on a concept, and now you're voting on something that you haven't seen what it looks like. You haven't heard testimony on it. Even going back to Representative Zwanitzer's idea for a bill draft, you're not voting on a formal bill draft, which will require a majority of both bodies to move that legislation in sponsorship form out of the committee. So I don't think there's, other than, I think the chairman can properly make sure that we don't overload our staff with too many bill drafts and requests. But I really don't think that this committee needs to vote on every proposal at this point in time. I think we get ahead of ourselves when we do that. and I would just say maybe unless there's an adamant objection on the committee to a bill draft, like, I really think we're wasting our time, we're wasting staff time, we're wasting this committee time. I think if a member said that on a topic as a chairman, I would say, okay, let's not move it forward unless, we just wouldn't do that. But, I don't think we're doing our next meeting service by voting on all these matters when we haven't heard testimony on anything. We don't even know what we're voting on. So I don't know if that, and I'm asking for a little bit of an opinion from the committee. If that makes you uncomfortable and you want to vote on ideas to bring the bills forward, then we can do that. If that's really what you want to do. But if you feel comfortable with having the bill drafted and then hearing testimony on it, and then saying, let's not even schedule that for the next meeting, you can do that too.
Yeah, so committee, I've experienced this in the last couple of years, primarily at the first meeting where there is this hesitation because we just come off of session where we do this rocket docket of voting on bills and it feels the same way. And it feels like we're making something into law and then we start all over again in the interim. And these are just conceptual ideas, right? Of having something tangible to work on and to work through and discuss and hear public testimony on, which is the purpose of the interim. So I just want to encourage kind of more flexibility that you're not being asked to make your final vote or to make something into law today. These are just conceptual ideas. And so more concept, the reverse of what Chairman Olson is asking for is very dangerous, which is all of us could just direct a bill draft to be made without a vote or consensus from the committee, of which we'll have chaos. And there'll be lots and lots of bill drafts from anyone. And so I do think it's the history of this committee to have consensus for the creation of a bill draft. And that's the committee's will. But at this point, I would just caution the committee that you're not voting on laws right now. We're just voting on conceptual ideas. So we would urge a more broad view of some of these concepts you're hearing that are intending to solve problems. Vice Chairman of the House Judiciary, Representative Washut.
Thank you, Madam Chair.
Yes, we are still voting on something. There's a motion on the table.
Which motion? The motion to suspend the vote or the motion to?
I didn't hear a motion to suspend the vote. Representative Washut, discussion though. Please give us your comments.
So my comment on this idea of bringing these before the committee is while we haven't heard all the testimony, we got a lot of information and I spent a lot of time reading about this material. And so if there is no energy within the committee to go down a certain pathway, I think it's appropriate for the committee to, cut bait today.
So Representative Washut will be voting no. Further discussion on the motion? Although let's retake the motion. All those in favor of Representative Swadetzer's motion to have a bill draft conceptually for a unified court system, please raise your hand. All those opposed, please raise your hand. And that vote count?
I had 9-5, Madam
Right.
Chairman.
All right, so that motion passes. Further motions? Representative Provenza?
Thank you, Madam Chairwoman. I would like to motion to have a bill drafted to add a district court judge in Natrona County and a district court judge in Laramie County. Sorry.
Well,
Representative Provenza, you want a motion for a district court judge in Natrona County and another one where? I'm sorry.
I'll just motion to have a district court judge added in Natrona County, one single.
Is there a second?
Second.
Seconded by Representative Yen. Discussion, Co-Chairman Olson.
Yeah, and maybe we may have been flying too fast, but one of the bills that we asked for it works towards that solution. It was resurrecting a bill draft from previous years that creates an automated system where that becomes more automatic in statute, and then we don't have to. The idea with that bill is we could work that into the discussion, but the idea is to work towards that solution of filling those FTEs that are needed.
I would say further discussion on that for the committee's history is that there's been a couple of bill drafts. I know that there was a bill draft created for a need, I believe in Uinta County for another judge, and in another location, we've seen a couple of bill drafts as a result of great need in those jurisdictions. So I do see them being as two separate issues myself. One is solving an immediate problem for an immediate need for a judicial district court judge. And the other is creating that process inherent within our workload to evaluate those needs. So I see them as being two different issues, both appropriate. So further discussion on Representative Provenza's motion for the district court judge in Natrona County or whatever location that might be. Representative Provenza.
Thank you, Madam Chairwoman. I just want to ask the committee to support this. We don't, it doesn't necessarily have to be Natrona, but we heard that there is seriously a need that we need to fill, and we would be harming our constituents to further have less access to justice. And so whether it be Natrona or another county is another conversation that I believe is warranted for our second meeting. Thank you.
All right, all those in favor, please say aye.
Aye.
All those opposed, say no.
No.
That motion has passed. All right, further action on this item? All right, seeing none, committee, we are going to briefly hear the introduction of our next topic for the review of non-competes from LSO. Mr. Fuller will provide that overview, and then we'll finish that out after lunch from Representative Clerks, who will explain some of those pieces. So just as a point of clarity, hopefully we'll be able to break for lunch at about 12:10, 12:15, or actually with accurate time, that clock is wrong. Yeah, about 12:10, 12:15. And then we'll come back around 1:15, finish out non-competes, probably devote maybe about 30 minutes to that, 30 to 45 minutes. And then we'll move on to the bias crime reporting, which I think there's a lot of public testimony on that. So just a point of clarity for where we're going. Mr. Fuller, please proceed.
Yep.
Madam Chairman, I'd just like to point out that just for the record that we are an hour and a half behind.
An hour, we
We're
are.
equally an hour and a half behind tomorrow or yesterday at this time too. So
It's good to be
we're in
co-chairs.
sync.
Madam Chairman, members of the committee, this is material 8-01. And I'll dispense with discussion of the other states in the 10th Circuit that are included in that memo that highlight the different approaches. So I'll focus for now only on Wyoming's law. Just generally, non-compete clauses or covenants not to compete are where an employee agrees not to enter into or engage in a similar profession or trade in competition against that employer. These clauses or covenants may be limited by duration or geography or both, most common. Originally, these were considered illegal restraints of trade, but with a shift away from, say, an apprenticeship system toward an employer-employee relationship, courts started to consider whether those were reasonable restrictions. Generally, courts have upheld these clauses when there is a proper balance between the competing interests of an employer and an employee. Put another way, the conflict between the freedom to contract versus the freedom to work. There is no, at least as far as I could find, no statute in Wyoming law that addresses these directly. Through case law, in Wyoming, non-compete clauses are enforceable if they are in writing, part of a contract of employment. They're based on reasonable consideration. They're not against public policy, and they are reasonable in durational and geographical limitations. Courts will consider various factors in determining their reasonableness, including bargaining power between the two positions, the risk of losing customers, knowledge and training that went into that employee-employer relationship, and any other current conditions of employment. Clauses will only be upheld if they are no wider than reasonably necessary for the protection of the employer's business and do not impose undue hardship on the employee with due regard for the interests of the public. Various cases have examined non-compete clauses in Wyoming. I'll just briefly highlight a couple of them. A non-compete clause that limited a veterinarian from practicing for 3 years within 5 miles of a city Where the veterinarian previously practiced was reasonable in part. The court had no issue with the geography, but the durational requirement was too long, and the court changed that, the Wyoming Supreme Court changed that to a 1-year durational requirement. An agreement that prevented a repairman from working for 7 years in an employer's area, which was 3 counties, was unreasonable. An agreement where an employee agreed not to compete directly or indirectly with the former business for 3 years and not use any confidential information gained from that previous employer was reasonable. The court has also noted that it can enforce a narrower term without arbitrarily invalidating the entire agreement. And then I'd also note that these agreements are used in other contexts. For example, a non-compete as part of a divorce, if a business is included as part of that divorce decree, as well as these are used in the sales of businesses to other entities. There may be non-compete clauses included in those. As for other states, I would just note that some states have taken, in terms of statutes, have taken different approaches. Some have as the baseline that non-compete clauses are void, and then include exceptions in those statutes. Colorado, for example, would include business sales as an exception, protecting trade secrets or recovering expenses. Some other states have more limited statutes that say any non-compete agreements that are longer than 1 year are void. So there are different approaches with that. With that, Madam Chairman, that's a very quick overview. Happy to answer any questions.
Thank you, Mr. Fuller. A really great memo and good overview there. Questions from Mr. Fuller? All right, seeing none and sensing you might be ready for a break and lunch. Appreciate all the hard work you did this morning, committee. We heard a lot of great testimony and a lot of work to move forward in the interim. We will come back at 1:15, give you a little bit of extra time for travel, and we'll start again. And with that, we'll hear from Representative Stith at 1:15, who asked this committee to bring this issue forward. So look forward to seeing you after lunch. For those of you that are here and interested on bias crime reporting, I know there's a lot of stakeholders out there watching. I anticipate that we'll get to that topic probably at around 1:45-ish, just to plan your schedules. Thank you so much.